Operator Siting Scorecard will provide COGC's staff with a siting tool to use in accordance with existing siting rules and which can be consistently applied and used to objectively evaluate locations. This rulemaking provides you with the direction, authority, and opportunity to implement this comprehensive siting tool. I recognized the need for the additional siting tools nearly a year ago, but had no idea what these tools might be. Until I found this email between this, until I found this email between COGC staff and Great Western Oil and Gas. It was posted on the COGCC's website. After reading through it several times, I recognized positive steps being taken by the staff and realized an opportunity to supplement and enhance these current practices. Multiple factors are now being looked at by the staff during the permit review process. No longer only the operator's cost and surface owner's preferences. Obtaining supporting documentation goes beyond the past practice of just allowing an operator to provide a brief narrative with minimal data and information. The practice that's now being utilized by the staff is an incredible step in the right direction. But it's important that this commission enhance the practice through the rulemaking and establish rules and siting tools that authorize the staff to perform comprehensive siting analysis and alternative location analysis consistently and objectively. The operator siting scorecard is designed to enhance and supplement the current practice of asking the operator to provide justification for the proposed location. It encourages responsible site selection and will ultimately aid in streamlining the permitting process for operators and staff. The operator siting scorecard template I provided is designed to illustrate an executive level view of a siting scorecard database. Establishing a database program that allows operators and staff to input, as well as allows COGCC staff to adjust the siting criteria for different locations throughout Colorado, such as the DJ Basin and West Slope, will allow this siting tool to have expansive and meaningful impacts through the implementation and use. Rules, policies, and siting tools must provide benefit and a reasonable level of balance to all affected parties in order for them to be effective and to resolve conflicts. As you can see, implementation of the operator siting scorecard will provide benefit for all parties identified. This scorecard will also be a tool that can be adapted over time as challenges and conflicts change. Thank you for your time, and I'd be happy to answer any questions you may have.
Thank you, Ms. Hall. Any questions? Yes, there is. Commissioner Craig.
Just quick, I guess this is on. Let me just go ahead and make a comment about the way you've stated your technical feasibility and your economic feasibility. When I entered this industry way long time ago, the thing that we were trained to do was to try to achieve maximum efficient recovery. We have since changed, I would say, to more of an optimized maximum or an optimized efficient recovery. Technically capable of reaching is not adequate. Just being able to reach is not able to achieve an optimized efficient recovery. Under economic feasibility, the economic capability to develop, to me, is more about the company as opposed to what is going to be achieved from producing and developing those assets. So again, I would say it has to be an economic optimization. All these other things are factored into this optimized efficient recovery, and every single oil company has to go ahead and achieve that. Otherwise, particularly in today's $39 environment, they're not going to be around to go ahead and implement those best management practices. So again, maybe it's just me being sensitive to the wording, but there's more involved than just, being able to reach an asset or being economically capable.
Sure. And may I respond?
Please.
Thank you. And I do appreciate that. I struggled to get it down to a point where it could just be a single page that I could hand out to you and try to just kind of cover kind of the basis. I actually had that broken down from 9 pages of detailed analysis that I had done. And as I mentioned, it would be more of a database, and there will be some locations that a local government may say, we want it here, and there may be no technically feasible way. So it may be an absolute, but they're also, in comparing various locations and kind of scoring them, kind of the optimal mid-range and possibly not feasible at all, it allows to find that most appropriate location that it may be technically feasible, and that's the start, but then it becomes, does it get into the, are they going to strand minerals? Are they going, it gets into the details of it, and I apologize. What I tried to do was back away from all of the detail that I had, because Director Lepore's staff, they're the experts, and they really are the ones that do this every day and know exactly what it is. And so while I went through and had 9 to 10 pages of what I felt were important factors, I didn't think that that was necessarily the final answer. So it was something that I'd be happy to sit and, if it's something that you feel valuable, discuss with Director Lepore or his staff in the future. But I did look at kind of ranking them and really finding the appropriate location. Does that help answer? Okay.
Additional questions? Thank you very much, Ms. Hall.
Thank you.
Well, Ms. Murphy, I'll just take a guess. Adams County.
That's a good guess, but I don't believe Adams County is planning on presenting on this topic. So I would suggest the allied local governments join us and present to us, and then industry will follow.
I'm guessing Boulder County representative is going to take the lead. Who would that be?
Kim Sanchez, Chief Planner with Boulder County. I will start us off. We, the Allied Local Government Group, who are not just comprised of Boulder County, but I'll remind you, comprised of the City and County of Broomfield, City of Brighton, City of Fort Collins, City of Longmont, City of Loveland, City of Thornton, and La Plata County. We all spoke, we spoke at the last hearing as to why these rules, including BMPs and mitigation measures, should be applied to any large-scale facility, regardless of where they are, not just in UMAs. As you might recall, the way that we propose to do this is by changing the definition of large UMA facility to simply large-scale oil and gas facility, so that the provisions related to siting and mitigation measures would be applied more broadly to those facilities wherever they may be sited. The point of recommendation 17, in our view, is to reduce the impacts on people from large-scale facilities, which in turn reduces the fear of the impacts on these people. The trend towards larger facilities that we're seeing and talking about has a significant effect. Not only is drilling occurring in areas where it's not expected, it's now occurring at an unprecedented scale and duration. The 4-well site that we used to consider large is now being topped by wells of 8 to 10 to 12 to 16 to more well sites, plus all their tanks and ancillary equipment. Recommendation 17 is trying to reduce the tension that Director Lepore was referring to earlier this morning, and to reduce the level of angst, anxiety, frustration, and fear that people who have these large-scale facilities close to them experience. The way that you do that, we propose, is to show with some degree of certainty that the impacts that these large-scale facilities produce will be addressed, and to outline specifically how this will be accomplished in the proposed rules. So while we appreciate that the COGC staff included some BMPs and mitigation measures for large-scale facilities as requirements in the 600 series, our objections are with the applicability of these requirements only to large-scale facilities within UMAs, and the omission of siting tools, at least with the strength that we think is necessary. Recommendation 17 is not just about mitigation. Siting tools are critical and an important piece of this recommendation. The idea behind the third issue in Recommendation 17 is to include siting tools to locate facilities away from residential areas when feasible. And where siting tools are not possible, to then require mitigations to limit the intensity and scale of operations, as well as other mitigations on neighboring communities. This follows a basic and important mantra that we use in the planning world, which is to first avoid, then minimize, then mitigate impacts. There's an inherent logic in this approach, this hierarchical approach that focuses on the importance of siting and location where you put something in the first place. The COGCC cannot possibly mitigate all of the impacts of placing a large-scale industrial facility near homes. The best way to address the impacts of noise, dust, traffic, odors, chemical releases, and fires is to site oil and gas facilities a safe distance away from people. That is, to site them out of UMAs and residential areas to the extent possible in the first place. And then if they have to be located in these denser areas near where people live, then you minimize and mitigate the impacts through the use of BMPs and mitigation measures, including duration limits. So that brings us to the topic of duration limits. Since the last hearing, the rules in 604 C4B little I related to duration are proposed to be struck. Aside from this procedurally being sort of an odd thing to drop a part of the draft rules midstream before parties have had an opportunity to comment on them, and at least to our knowledge without direction from the commission to omit those rules, the duration limits are exceedingly important, and we should be spending our time talking about how to make them work better. Discretion is great, and Mr. Matter confirming that the director's authority to impose duration limits is a small comfort, but if this isn't showing up as a requirement in the rule, it is not the standard. A time limit on operations is necessary. It's unrealistic and unfair to expect residents in close proximity from a major industrial activity to deal with its noise, dust, emission, and traffic 24 hours a day, every day of the week for months on end. Without the certainty of mandatory protections, impacted residents will remain uncertain for a lot longer than that the duration limits will be imposed, and have to stay involved through months of process, months of uncertainty, months of unnecessary anxiety and fear. The public wants certainty that large-scale facilities will be placed near homes only as a last resort. They want certainty that even if wells are placed in their neighborhood, mitigations will be required. They want certainty that if drilling has to occur near their homes, it won't be allowed indefinitely. There's opportunity here. There's opportunity here, but you have to be the ones to strengthen the rules and to add the excluded parts back in. Striking the duration provisions from the rules and relying on discretion allows for the possibility that they will be employed, but not the assurance that they absolutely will be required. The point is to spell out the way the impacts will be addressed and provide certainty and let people know we will be requiring these mitigations. This will have a significant impact on the fear that is out there. It will convert from uncertainty to this is what we'll do, don't worry. We will avoid, minimize, and finally mitigate the impacts that are being experienced. In sum, the points that we'd like to offer to you are large is large, whether it's affecting one house or many. Mitigation and BMPs should be applied to all large-scale facilities, not only those in UMAs. Secondly, don't forget about the importance of the siting tools. So much rides on the location. What impacts will be felt, how much they will be felt, and for how long. We have to let the siting of these facilities do as much of the work as possible. The alternate location analysis was a topic that we already discussed with our proposed edits to 305A-B2 to be included in the notice of intent to construct a large-scale facility. Thank you to COGCC for giving that a nod. But we'd like to see that siting rationale beefed up to include an explanation as to why alternative locations were not chosen over the preferred option. And we'd like to see this idea of analyzing alternate locations as a siting tool added to the 600 series as well. Lastly, we support the inclusion of requirements, including duration limits, being defined and listed out in the rules, not just discretionary. A specific duration backstop is needed. Discretion in the proposed rules will create uncertainty for nearby residents, local governments, and industry, and this uncertainty only breeds conflict. The whole point of this effort is to try to diffuse the tension experienced by everyone here. You can't do that without addressing it directly in the rules.
Thank you, Ms. Sanchez. Anybody have a question? Did you have a number in mind for alternative sites to be considered?
Not a number of alternative sites, just the analysis that shows which sites have been given consideration and why they were excluded.
Thank you.
No further comments.
No, okay. That was good.
I might have a question.
Okay. All right, Commissioner
I'm kidding.
Benton, he's not kidding.
No, he isn't?
No.
So two things, and we've talked quite a bit about the alternative location analysis, and I can't remember, I'd have to go back and look at the rule again, but I thought that the rule had something in there with respect to proposed alternative locations considered or something along that line. So again, I guess I'd ask the question, to me, it says you have to do that analysis already. So why would we want to go any further than what's already there?
So there are two sections that we have discussed the alternative location analysis. The first is in 305A-B2, and that's with the notice of intent to construct a large-scale facility. And I think we talked a little bit further about this in a small group. And number two refers to the director's proposed language was a description of the siting rationale for proposing to locate the facility within the urban mitigation area, including a description of other sites considered. What we'd like to see added to that is the last line of Boulder County's alternative draft rules, which says the addition of why the alternative locations were not chosen over its preferred option. So what we don't want to see is just an operator submitting a description saying, yes, check. We did consider alternative locations. We'd like to see them show their work. What locations did you consider and why or why not were those not feasible locations?
Okay. So I'll answer this as an operator, including a description. I can't just say yes. That won't work for me. If I operate under this wording, I have to provide a description, which means I looked at this and I considered this and I adopted something else. So, you know, I understand, and it certainly is something worth considering that there may need to be something else in there, but to me, the way it's written now, just checking a box is not going to work.
So a description of the other sites considered means that they could provide a list of the other sites that were considered. What we're proposing to be added is why the alternative locations were not chosen over the preferred option. So
Yeah.
I think they're very close.
Depends on who's reading it and what you hear when you read that. To me, a description provides more than just a list.
Sure. In
But
our
it may be
perspective,
that
we'd
other
like to
folks
see a little bit
do
more
not.
meat on those bones.
All right. I'm always concerned, and I think Director Lepore alluded to this a little bit, it's just a comment about the duration limits, about the unintended consequences of imposing something without thinking through what may result from it. So it's just something to keep in mind, is that if we impose a duration limit, what possibly other consequences could come out other than what we hope would happen from that?
If I could go back to the alternate location analysis to further answer your question. The other place that we'd like to see some addition is in the 600 series. So if you look at the alternative draft rules that we're proposing, we are asking that large UMA facilities be changed again to large-scale facilities, and that first sentence should say that they're not sited within a designated setback location if reasonable alternative locations are available. So that's again to hit at that avoidance first, and then you get to mitigation second.
Okay, I get that part. Thank you.
Any other questions?
May I respond to the point on imposing a duration limit?
You certainly may.
The proposed language doesn't propose any fixed time limit. It instructs the director to impose a time limit. I think the considerations about unintended consequences could be taken into consideration by the director when he sets that time limit. There is no specific time limit being imposed.
Just as a comment.
And that, I think I agree with that, because you're saying it's at the discretion of the director to consider that in all circumstances. That's what I heard you say.
Right. I mean, I'm a firm believer that procedure can address a lot of substantive issues. Here, we're asking for a procedure that the director will impose a time limit to address the substantive issues of the significant impact by those facilities.
Commissioner Craig.
I just have a comment. I'm very nervous about these duration limits, particularly during the drilling phase. If you ever get into trouble time with a hole and you're fighting that well, having some deadline, it's a safety issue with me. And that is the thing that concerns me the most, particularly during the drilling phase. You need the flexibility to go ahead and adequately drill that hole. And I'm concerned that saying, well, you only get this many days, I don't know, to me that just, I have operational issues with that comment.
And if I could respond to that, the original draft included a provision to allow the director to grant a one-time extension of the duration limit, not to exceed 30 days. But now this whole section is being proposed to be struck. So we would like to see some acknowledgement of a duration limit included in the regs.
I have personally been involved with wells where 30 days would not have been nearly adequate.
Well, more discussion on that timeline would be appropriate then.
Are there questions? Commissioner Wall.
Do you see anything in here that excludes or preempts the CDPHE consultation from including a duration limit?
I'm not sure that I would be the right person to answer that question. I don't offhand.
Okay. Okay.
Okay.
I'm just looking for other places with pre-existing rule or process that would allow for a duration limit to come through the potential for using a CDPHE consultation.
Sure, we'd certainly be supportive of exploring other ways to get at the same end.
Okay, thanks.
One more time. Thank you very much.
Thank you.
Best I can tell, we're down to industry. Up to industry.
Industry's turn.
Do you want to do that? Or is that lunchtime? It's 12:30, I guess. Lunch is.
Okay, you are going to discuss with us mitigation and
Just wait for a second for our slides to come up. PowerPoint, let's see.
BMPs and mitigation measures.
This is approved. Yeah. down count. Right there. Just pick one.
Industry final, industry presentation, right in the middle, right in the middle. There you go.
Sierra Club.
Yeah.
Everyone has to give their presentation with somebody else's slide. You get somebody else's presentation, that would be different.
Left of the advance.
That looks. That looks. We saw that.
I think it starts on slide 57 according to my notes.
Yes.
There you go. Okay, are we ready?
We're on the clock. Let me begin by reiterating something that Commissioner King said earlier, which was that you have been very successful these past few years in working through these issues on a site-specific basis and reaching reasonable and appropriate results regarding siting and mitigation. You're at your best and your strongest when you're dealing with site-specific facts. I'd suggest you're much weaker when you're dealing with regulatory generalities. Now, I'm going to talk very briefly about some of the mitigation language in the draft rules and then turn the microphone over to Ken Wanstolen and a panel of industry experts. The first point is that proposed Rule 604C4, which we've included, requires the use of best available technology. Proposed Rule 604C4B refers to mitigation to the maximum extent achievable. That's new terminology that creates ambiguity and uncertainty. It arguably prescribes the use of state-of-the-art technology without regard for any cost considerations or the effectiveness of other options. And you should instead use the phrase technically feasible and economically practicable, which is the touchstone for mitigation under existing regulations in the Act itself. Technically feasible and economically practicable appears in 11 of your current regulations, including Rules 305 and 604 as depicted on this slide. It's been repeatedly referenced in statements of basis and purpose from recent rulemakings that touch on mitigation, including the 2008 comprehensive rulemaking, the setback rulemaking in 2013, and your lessons learned rulemaking earlier this year. And it also comes directly from the Oil and Gas Conservation Act, which authorizes this commission to regulate operations and impose mitigation, taking into consideration cost effectiveness and technical feasibility. So the mitigation language in the draft rules should be revised slightly to replace the references to best available technology and maximum extent achievable and conform that to the existing regulations and statute. Now, I'm going to turn the microphone over to Ken.
Good morning, Commissioners. We have a good technical panel for you today. It's going to be the last time you'll have technical witnesses available to you for the industry. So I would ask that you bring your questions on BMPs and other matters during this panel, as well as talking about duration. It might be most effective if you hold the questions to the end so that any of these panelists can jump in as appropriate, but I leave that to your indulgence. And just before starting that, I want to go back just briefly to this issue of the opt-in versus the opt-out. I think there's some confusion and ambiguity in the rule as written. 305 AF2, page 4 of 11 of the most recent, the third draft, really appears to indicate that this opt-out would have to happen on a case-by-case basis. It reads, an operator may initiate the Form 2A process once any of the following occur, and then it uses the present tense to local government with land use authority waives, not has waived, waives the 305A procedures, and the operator provides written confirmation of the waiver. So that sounds like you have to give the notice and then get the waiver, provide written confirmation of the waiver. I would note that the statement of basis and purpose talks about a global waiver, but that doesn't appear to be the way the rule is written. So if you're going to stick with an opt-out as opposed to the preferred opt-in, let's at least get the language clear. And as Mr. Swain said, there is a big difference between asking a local government to take an action to get out from under purported state authority as opposed to asking to get under the program. And if you look back at recommendation 17, it says this recommendation is for interested local governments. And I think the most appropriate thing is express your interest, and then you're in the rule. And with that, I'm going to turn now to the BMPs, and in particular, I'm going to have to talk about the duration. I recognize that the duration piece has been stricken from the third iteration. Obviously, Boulder County and other local governments want to see it put back in. There's been substantial discussion about that, so we're going to have to make the record on this point. So we have a panel of small, mid, and large cap public companies and a private company, and they're going to address three key elements of the statute. And this is the statute that is referred to in the statement of basis, specific statutory authority and purpose underlying this rulemaking. Now, Mr. Matter has provided a subsequent memorandum that cites to a different provision in the Act, but this is the one that is in your statement of basis and purpose, and it has provisos in there. So we are going to have this panel address, is a duration limit necessary to protect public health, safety, and welfare? For that matter, is it even desirable? You heard the mayor of Erie say, what we want is for the industry to get in and get out. And I think some of the questions have gotten to the point about is it necessary or desirable? Is a duration limit cost effective with respect to the impact on well economics? And is it technically feasible with respect to optimizing recovery and avoiding waste as your statute requires you to do? And also we have these panelists may be able to respond to some of the citizen comments on specific projects, and I think that'll be the case with our first witness, Mr. Rasmussen from Synergy.
Yeah, you can make a comment. We're not asking a question, we're just going to make a
I'm
comment.
just going to make a comment because I'm going to be listening to every single one of these technical experts. And in the back of my mind, I'm going to be thinking about the fundamental of engineering, which is always to do more with less. Technically feasible and economically practicable. I want to understand how continuous improvement fits into that lingo. So with each of your presentation, I want to understand that because that's what fundamentally engineering is about. So that's how I'm going to be listening to all of you, just to let you know.
I'm sure they would like to thank you for your comment, but I'll just do it for them. Okay, where are we going?
Mr. Rasmussen.
Mr. Rasmussen.
Good. I believe it's happy lunch hour. I'm not real sure on my clock or my watch on me. Want to thank you for your time this morning. I may stray a little bit in the interest of trying to give you industry's point of view on a very hot topic here today on Wadley Farms. Prior to doing that, I'd like to credit, I guess, the process of which was led by Director Lepore and the Commission on showing how things can work, i.e. the PACE project. I know that the citizens' input and they feel very strong that this would not have come to this resolution without their input. From an industry person's standpoint and one of the operators that's doing the most of the municipal development and UMA type development on our horizon, I'm here to tell you this process is already in place. And what we're doing with Wadley, to give you a quick synopsis and history, you had a handout that was new to you this morning, is not in the PowerPoint. I guess, well, the old one's up, so I can speak to what you have in front of you will work in what we have on the slide presentation today. The left slide here is the proposed 30-plus acres that Synergy bought 4 years ago to develop directional wells within this spacing unit. Obviously, the evolution of horizontal drilling has changed a lot of what industry is doing, so we're being trying to be proactive and not reactive to how do we develop these minerals that we have under lease and or are held by production. What you see on the right slide would be if we were to drill from Wadley 20 plus wells, I think it's 18 is what we have that is our legal unit for the space that our geology and engineers have looked at from that site. Again, it's 30 plus acres. It does fit as far as the setbacks. What happened back in February of this year is we approached Adams County on their MOU process and executed the MOU with them in March. They asked us to hold a neighborhood meeting. Their requirements were that there's a certain radius from that site that we notice those neighbors. We noticed those neighbors, and it was 40 or 50 people showed up to the meeting. There was some contentious, worrisome questions that we tried to address to the best of our abilities, and we went ahead and spent 3+ hours with the group of people that were there that evening. As that happened, there was a big uproar, if you will, with the rest of the people in Wadley that felt like we were trying to leave them out of the process. We simply were following Adams County's request for what that setback was, or that radius was, to go ahead and show this process. Long story short, they requested we hold another neighborhood meeting, which we did in September. By that time, obviously, a lot of the opposing groups had really rallied a large contingent to go ahead and speak against this proposed location. What we did in the meantime from May to September was to meet with the Adams County Commissioners, and we sat down one-on-one with them and heard their concerns, because these are the people representing the constituents within this unit. We also reached out on a one-on-one basis. You heard testimony earlier in regards to IT concerns on a drilling rig. That was our reach out to residents of Wadley, allowing them onto one of our drilling locations. Did not know it would go to an IT issue, but that's truly, we were trying to show them sound walls, size of location, tank batteries, the quietness of the rig, the best practices that are in place during drilling process. Didn't get any feedback on that. That being said, is we offered to Adams County, one, to hold off until 17 and 20 were heard, putting and submitting any 2 and 2A opportunities. We have not staked this location. We have not surveyed this location for development. It is a second inning of a 9-inning game process where we are still today. We want to see how things come out ourselves here. The conditions that we would develop this with would be oil pipelines. There's existing 4 wells that are ready that are trucked out, where they have to open the thief hatch to go ahead and haul loads. That would all be excluded in future development. One of the things we're looking at, and I don't know if the next, if the next slide will show it or not. I do have a slide. If you can flip to the 3rd page, your alternate site assessment area of the handout you have is we have located, and I don't necessarily want to put this out there, because anytime an oil company is looking at buying property, it seems to double in value pretty quickly. But we have located an alternate site that may be able to drill part of this unit for us. It would not totally get rid of Wadley because of the reach of our kicks for our laterals, but it would go ahead and take Wadley down to a third or less than half of the number of wells that we're proposing today at 16 to 20 in that range as our geology figures through. We have looked at 3 other sites. They've all been ruled out because of floodplains, setbacks to existing schools, no access for pipeline to be able to get in there to develop that location. So what I'm trying to message to you is that this is already happening between industry and the Oil and Gas Commission, all the things that you're considering today. On the duration issue, this, if we were to drill an 18-well pad, as you look at the right slide here of the yellow proposed, what it would look like from a 35-acre farm that fits the setbacks, is we would have to come in 2 and 3 times, and we would experience waste. I'll let some of the more technical people on our panel figure through that, but the expense of doing that, the time frame of doing that, and the impact on those neighbors versus getting in there once. We are presently, as industry, drilling mid and extended reach lateral wells in less than a week's time. That is a big impact if you drill them all from one location. We recognize that. Ironically, from our experience of drilling a lot of municipal areas within 500 feet of people, we don't get complaints on the drilling side. It's the completion side that we can't quiet those big horsepower engines. The drilling side with an electric rig or a natural gas rig, very sincerely, we got zero, not a one, complaint in Greeley recently with us drilling 4 horizontal wells from one pad, where there'd been drilling activity prior to with another operator, and that rig that they had was a diesel-driven rig that was loud with the brakes and the squeaking, and they got complaints nightly. So what we're using technology-wise, we are not getting the complaints on the drilling side. The completion side, yes, we have some issues with the revving of those engines and the high decibel levels. We're meeting those decibel levels through sound and light mitigation, but it's not something that doesn't go unnoticed. So with that being said, in regards to duration, I'll yield to the rest of the panel so they can give you more clarity on the issues that are at hand. Thank you.
Thank you, Craig. Our next panelist is Boyd McMaster from Extraction.
Hi, my name is,
It's on.
okay. My name is Boyd McMaster with Extraction. I'm an engineer with my duties predominantly with planning. I think before I get into my prepared remarks, I would like to respond to what Commissioner Craig brought up. In the industry, all companies represented here, without rules, without regulations, have innovated. We've put in sound walls. We've upped the game on landscaping and berming. We've started recycling water. There's a lot of innovation we've done, and there was no rule in place because our goal ultimately is we live and operate in these communities. We're not outside investors. We're here, and we appreciate what our neighbors are doing, and it impacts us as well. So I just want to make sure that as an opening comment that there's a lot of innovation and continuous improvement going on in the field, and it is not going to be driven by rulemaking. It's going to be driven by people who care. And as an industry, I've worked in multiple basins across the country, and I've never seen a group of people, as I've seen in the DJ Basin, who really care about the communities that we're operating in. So with that said, my prepared comments are as follows. I've participated in a number of community meetings and landowner discussions here in the DJ Basin, and we have a reoccurring theme that you've already heard here today, and that is get in, be safe, and get out. We are perfectly aligned with our communities, and we strive to safely reduce the amount of time we operate in our communities when operating in those communities is our location of last resort. Durational limits do not achieve this objective, and in fact would extend the duration of operations in communities. Additionally, ad hoc imposition of durational limits interferes with our ability to plan operations that reduce impacts to communities. Planning is a fundamental tool for implementing best management practices, or in the case at hand, best mitigation practices. Ad hoc imposition of durational limits creates uncertainty and unpredictability. To illustrate the more tangible effects of potential durational limits, I have the following information to share with the Commission, contrasting our current operating practices using best mitigation practices and 3 alternative scenarios illustrating how these operations might look with durational limits. As we've already heard here today, proposed Rule 604 does not specifically say how durational limits could be imposed, and that's what I refer to as the potential ad hoc basis. So I had to make some assumptions how they could potentially be imposed to illustrate how durational limits would likely increase impacts to our Colorado communities. These assumptions were: durational limits would be imposed on a calendar year basis. In my 3 scenarios, I assumed operators could potentially be limited to 90 or 120 days of drilling, completion, and stimulation operations per year. Additionally, I used the activity times presented by the staff and identified as the compilation of reported time to drill a well in the DJ Basin. All operators obviously vary, but for the purposes of this, I thought average was most appropriate. I assumed in my 3 scenarios that the operators would be drilling 16 2-mile long laterals from a single pad, which is consistent with the stakeholders' position that these are locations of last resort. Finally, If you want a more complete description of the activities that are depicted on this graph, if you refer to the legend, I tried to itemize those out for everybody so that if there was any doubt, they could see. Here are the points that I need to make about this chart. First, extraction's current operational practices, which include employing best management practices, using sound walls, electricity where it's available, would have us concluding drilling and completion activities in less than 1 year. That's the bottom graph there. In all other duration impact scenarios, we would not complete our activities until well into year 2, and in the 90-day staggered approach until year 4. In all of the durational impact scenarios, operators would not begin surface reclamation at their drilling sites for over 2 years. This point is particularly important to our communities as this marks the point in the life cycle of our operations where operators begin implementing best management practices to alleviate visual impacts of its operations, which includes reseeding, berms, fencing, planting trees. The 90-day scenario results in a particularly acute process problem in that under current commissional rules, drilling permits expire after 2 years. And there is no mechanism for extensions. None of these durational limit scenarios fulfill stakeholders' objective of get in, be safe, get out. In fact, in each of these 3 scenarios, total project durations increase, which simply stated means we're in communities longer, you're going to get more complaints. If we go to the next of my 3 slides. On the project duration timeline chart there to the left, the blue bar illustrates that the durational limits do not change the amount of times it takes to drill and complete a well, while the red bars illustrate the dramatic corresponding increase in project durations. However, if an operator chose to use a staggered approach to complying with the durational limits, it would result in 200 to 400% more traffic in communities. This is the unintended consequences we keep referring about. This would be a direct result of having to move in and move out of the community the equipment necessary for drilling and completion operations at the end of each durational limit. At this point, I think it's appropriate to put in my disclaimer that I don't really know how durational limits will be imposed, which is part and parcel of the issue of the problem. So, you know, any of the assumptions here that I've made are easily attacked because I don't know, and that's the predictability and certainty issue. However, what we can learn from these scenarios is that durational limits in all cases extend the amount of time I have to operate in the communities, potentially create more truck traffic in communities, but do not change the number of drilling and completion activity days, which is the activity which seems to drive the most concern from our communities. Additionally, durational limits would have other non-obvious impacts to communities in the state. As illustrated on the second chart on this page on the right, the green and the black, durational limits would lead to loss of tax revenues to communities at a time when they need them most, as well as lost recovery of natural resources or waste as it is defined by the Commission statutes, rules, and regulations. The loss of tax revenues in these 3 scenarios is the result of 2 causes. One is the delay of operators completing the wells and starting production operations, which might be better categorized as deferred taxes. However, the biggest loss in tax revenue to local governments comes from the potential damage to the reservoir from spreading operations over a long period of time and directly correlates to the waste problem caused by durational limits. I'm not going to get into an in-depth discussion about that because I have a couple colleagues here who are very well versed in this, and I believe they are going to have a discussion. I just want to say that the durational impacts go beyond what is obvious and apparent. So next slide. In conclusion, I'll leave you with these final thoughts. The current proposed language of Rule 604 does not have the predictability and certainty operators need to plan their activities. I was pleasantly surprised by the 2 previous presenters. You can find that we have agreement on that. In particular, the time horizon for planning pipeline infrastructure typically takes in excess of 24 months of pre-planning and execution and rely upon planners knowing with some degree of certainty when wells will be drilled. The current proposed language of Rule 604 does not provide any guidance as to how durational limits would be imposed. As a result, planners such as myself cannot predict with any degree of reasonable certainty when wells would likely be drilled. And as such, the unintended result of this rule will be to inhibit or altogether eliminate operators investing in pipelines and other supporting infrastructure. This is not an outcome that benefits any stakeholder, and certainly not an intended outcome of the task force. It is, however, an unintended likely consequence of implementing durational limits. So thank you for your time and your attention. It is our conclusion from this analysis that durational limits are contrary to the objective of get in, operate safely, and get out. Thank you.
Running short on time, so we're going to move very quickly here to Mr. Cocciolone from Anadarko and finally Mr. Roche from PDC.
Excuse me. Yes, David Cocciolone with Anadarko. I talked at the last hearing, and what you heard me say there was I mentioned the benefits of the tankless facilities and that how much it reduced truck traffic and the impact on roads. I think what you see with any duration limits is that opposite negative effect here. That is, anytime you have to mobilize on and off location, that's the instance when you're going to see the most truck traffic involved. And when we're talking with municipalities, one thing they're saying is that one of their two biggest issues is truck traffic and roads. They want us to see us just mobilize one time and then get off location when we can, not continually going back and forth. The other thing is, we come to the question, what happens if we're 98% complete, even if we have an extension and we have to leave location? If it's not economic to come back to location, we may leave stranded resources on the table. Furthermore, upon talking to a lot of the surface owners, one of the things they're concerned about is they want their land reclaimed. With duration limits, if we are on location for X amount of time, leave, and then come back at a later date, that's longer when their land stays unreclaimed and not in the condition that they so want. Another thing we've seen is definitely the stimulation of newer wells on horizontals that were previously completed. We've seen a negative impact on when we frack new wells, how older wells respond. So any duration limits could definitely impact the overall production on any given pad. And then finally, any production would definitely come online much later than when our initial cost occurred. So overall, what you're seeing is you're either seeing an increased cost from duration or you're seeing a downside in the overall production, which of course is definitely going to impact our overall economics in this case. If you go quickly to the next slide, I'll just briefly touch about this one because I did mention that when we frack newer wells, oftentimes it's the older wells that see an impact. And what we're seeing is that 50% of the time when we complete a new well and it has a horizontal within 1,500 feet, we are seeing a negative impact. And those can be seen from the bottom two graphs on the right. You can see oil and gas production, oil in red, gas in orange. And what you're seeing is in the first case, the middle case there, it took us quite a while until we could bring those wells online, which is right in the middle of the graph. It took us a while to bring those wells back online after fracking the new wells. And you can see performance afterwards wasn't as good. Whereas if you look at the bottommost graph, what happened there is we fracked an offset well. And what you can see is right in the middle of that graph, we were never able to get that well back online after we fracked the new well. So it definitely is real when we say when we frack new wells, if we have older horizontals near there, that we do have trouble many times getting them back online. And that's potentially what you could see with any duration type impacts when we've completed a few wells, leave, and then we have to come back and complete more. We definitely could see those negative impacts. Rushed through that a little, but I'll pass it on.
Mr. Roach will wrap up our witnesses.
So as
David alluded to, PDC also has identified the potential for risk of lost production through the same mechanism that he showed here. We have real world examples of offset production being impacted by new horizontal development. For those who may disagree that happens, I'll point to the wellbore integrity policy, which is in place specifically for the exact mechanics that we're talking about here. So there's not much discussion around whether or not this can happen. Given that there is a statistically significant chance of this happening, PDC very specifically would never approach this development program from a staggered perspective, which Mr. McMaster showed us, which would be drill a few wells, frack a few wells, come back later. We would drill as many wells as possible within the discretionary limitation time and choose to come back and frack after the quiet period. When considering discounted cash flow economics, every company needs to consider when they deploy their capital and when they actually begin production and drawing revenue off that program. And depending on what type of quiet period we're talking about, which in the current or the previous writings before they were removed were very discretionary, unable to tell us what that was. So there could be significant impacts if the quiet zone period between drilling and completions was significant. Of course, this assumes that all the wells that are in the program, Synergy's Watley Farm, say 18 wells, were able to be drilled within the designated limit. If we move forward, kind of another timing complication here is very specifically around budgeting and planning. PDC is a publicly traded corporation, and very specifically the duration limit, which again was discretionary, was tied to the permitting process. It's not unreasonable to assume, and I can tell you it's a fact at PDC, that when we generate our budgets, we very rarely have 100% of our permits approved or even submitted to the COGCC at the time the budget is approved by our board of directors. And obviously, if the permits go in and a time limit is imposed, that causes us to have to adjust our budgets. As you can see, there are some significant problems with that. We're bound with fiduciary responsibility for our shareholders, for our communities, for our surface owners, for our mineral owners. And of course, all this timing is tied to surface use agreements and agreements that are made with communities and people. So this discretionary permit-sensitive timing creates a lot of difficulties for the budgeting and planning process.
Thanks, Eric, and I'll just wrap up with a couple of remarks. This slide and the next one show the progress that the industry has been making in reducing drilling and completion times on its own, because there's an economic incentive. In fact, there's a business imperative to reduce these times and these costs. A year ago, Bill Barrett was taking 14 to 17 days to drill a 2-mile lateral. Today, it's 6 to 7 days. If we insert the heavy hand of government into this process and interrupt the ability of those companies who are spending tens of millions of dollars investing in these projects and how they run their business, we're going to see that progress come to a grinding halt. And in closing, I want to say I think this rule self-evidently does not meet the goals you've heard of clarity, consistency, and certainty, because it is discretionary and it's case by case. I just went through a Sarbanes-Oxley risk analysis process with my board of directors, which we're required to do as a public company, and I can tell you their assessment, my assessment of the risk in Colorado has gone up because of this potential rule or potential application of this on a case-by-case basis. More importantly, this rule does not satisfy the statutory requirements of necessity, cost effectiveness, and technical feasibility. With that, we close the panel and ask for your questions.
When you say this rule, you're talking about duration limits or the whole?
I'm talking specifically about the duration limits, Mr. Chairman, whether as a rule or as a condition of approval on a permit.
And commissioners, we do have just one more point. With respect to, as you deliberate and consider the language in this Rule 604, we would ask that you take into account and look at page 4 of the site mitigation basically page that was in the synergy presentation that was passed out today. What this does is it provides an example in support of the current Rule 604, as well as the staff's proposed Rule 604, that illustrates that BMP and mitigation measures are considered by operators as well as local governments and are best considered on a site-specific basis. So in addition to the duration pieces, we would also like you to take into account the mitigation measures that are utilized on a site-specific basis as well. Thank you.
Okay. Mr. Rasmussen.
All the above.
Doesn't double your.
Been that way 47 years, it's been that way.
I appreciate your presentation. One
Yes,
of the
sir.
things that struck me just a tiny bit, you indicated that your company had gone through a fair amount of effort, it appeared to me, to reach out to not only the elected folks in the county, but to impacted citizens, even
Yes,
to
sir.
the extent of expanding that universe a fair amount. In your judgment, it may sound like a leading question, it really isn't, but in your judgment, is that really worthwhile? Is that really, when you're looking at the big picture and getting the job that you want done in a timely manner, is that effort really pay?
You know, I would, yes, but I would qualify that, yes, that this is our first experience drilling in Adams County. We're one of the first oil and gas operators to sign their MOU. So as they work to keep their constituents informed, I'm talking their commissioners, we were willing to go ahead. Now, I will tell you this, if oil was at 90 and we were at a 3-rig program, we would have asked to expedite at the pace they told us when we met with them last March. So when they came back to us and said, hey, listen, this is contentious, obviously. We have some real concerns. We want to see your BMPs. We want, within their MOU, their last paragraph gives them all the wiggle room for adding conditions of approval before that is executed within Adams County. And we said, hey, let's go ahead and sit down, and whether it's 10, 12, 20, whatever those are, dust, noise and light, oil pipelines, no thief hatches, no emissions, all those things this is the only way as an operator in Adams, Weld, Larimer, Morgan County, where we operate where our assets are, that we would develop it. We want it to be developed, if it's developed on this parcel, as though we were the neighbors there also. The first 7 directional wells drilled by Synergy were 800 feet outside my back door. I can speak to it in the respect that we've been there, done it. It's a lot better than it was in 2009 when we drilled those wells. We don't use hay bales anymore, and we have decibel readers out there to make sure what our impacts are. And but for us, we did stand down at the request because it is a tough location. We've got their comment to me was come with some lower hanging fruit, come with an easier one, and we'll get the MOU executed. But it's on a case by case basis with them. So I hope that doesn't.
That helps.
Okay.
If, so you have this experience with the MOU. So let's say you're dealing with a municipality or county, whatever, and they want you to move that large facility, whatever it's defined as, a little further away from schools. You work at that, or you look at that as best you can? Or?
When you're drilling municipally, you are a lot of times hamstrung. Obviously, you saw earlier the Triple Creek, one of our peer groups is proposing. I credit them. I think part of what's being missed here through all of this is the fact that when a lot of these locations were first identified, we were drilling 1 mile laterals. And then the R&D, a small company like ours, we've always said the Nobles and Anadarkos and PDCs and Encanas are our R&D. And we're fast followers to best practices. Showed us that we can go 2, and now we're going to push the envelope to 2.5 miles to try to get some of those minerals so they're not stranded because they've been developed over. That being said is, yes, always. Moving it from the Fox Run location, from what the previous operator was, to the operator that has those mineral rights now, to the Triple Creek, to me, makes all the sense in the world. It's more than fits all the setbacks. We're not ever going to, when you move it from one backyard to another backyard, there's always going to be contention. So we are trying to go ahead as an industry, and fortunately for a lot of the bigger operators, they've got the low-hanging fruit. They don't have these tough ones. Our company has 41,000 net acres in the Wattenberg, and about a third of that is, we've drilled in 9 different municipalities under 9 different USRs: Erie, Windsor, Meade multiple times, Johnstown, Greeley multiple times. And to be quite honest with you, Greeley's one of the tougher ones, but they've got the plan in place because they've dealt with a lot of activities. So through experience, they know what they're asking for, and they're as tough as any. So that being said, is we always look to, is there an alternate site? In this case, we bought this property at Wadley for less than $700,000 4 years ago. The location that we're considering now is priced near $4 million for smaller acreage. Thank you, Cabela's, for running up, the price of per square foot acre now versus, per square foot. That being said, is we are very diligent in trying to minimize. If we were to drill Wadley with 18 wells, it would only be done with pipelines to where the trucks don't have to come in. We're going to find a way we want to try to offsite. We're looking at now through our partner in Halliburton on offsite fracking from over on Washington to where we can go ahead and pump the job where we don't have to be right amongst it. There's a lot of things we're looking at. That's why I said we're in the second inning. But we've had many conversations with staff, with the director directly, and with all the people that we'd be impacting with that development. We've met with Thornton face-to-face with them. So I have a meeting next week with the fire department of the city of Thornton. So we're working our tails off this industry to dot the i's and cross the t's to show it's safe and responsible. Or if it doesn't meet all the boxes, we don't drill it.
We'll hope it doesn't go into extra innings.
Amen.
Any questions for these experts? Commissioner Allward.
Thank you, Mr. Chair. Thank you all for your presentations and the graphics that helped me to keep track of what you're talking about. So I've got a question for you, Mr. McMaster. With your graphic, and your analysis of how long it might take under different sorts of pausing scenarios, what struck me is it seems like your analysis is based on no change in technology or techniques, no innovation. But yet, over the last several years and the last few minutes, your colleagues have been touting how innovation is leading to shorter and shorter drilling times. And they don't seem to indicate that it will ever stop, even though there is a zero lower bound. So how does your analysis, how much of it do I take into account using yesterday's technology versus what innovation might be spurred on by having such duration limits?
Thank you for the question. And yes, will there be innovation? Yes. But that's not predictable. It's not certain. And at some point you reach a technical limit of how fast you can do things. So I have to interpret the rules based on what I know I can do today and planning those projects. And in particular, I've got to know when I'm going to bring those wells online so that I can size the pipe to move things in and out of there without trucks. Or in most cases, we never are going to eliminate, but avoid and minimize.
Follow-up?
First question was with respect to, I believe you referred to a wellbore integrity policy. And can you elaborate on that just a little bit, please?
Yes, Commissioner. Basically, the wellbore integrity policy is something that was put into place, I believe, in 2013. Specifically, it's relates to horizontal development and offset existing vertical wells. So in the event that we are drilling and completing horizontal wells where there are pre-existing vertical wells, during fracturing operations, the offset vertical wells have to be mitigated to a point that if they see pressure impacts due to that hydraulic fracturing, that we don't have a wellbore integrity event. Specifically, it deals with top of cement on the backside of the production casing, whether or not the wellheads are adequately girded for pressure. Specifically, all wells require 5K wellheads under the policy. So the point to the policy is to protect the aquifer, and all the operators bend over backwards to make sure that they adhere to the policy. I think the point that I was trying to make was the fact that the policy exists is it basically the mechanics between where offset horizontals can impact existing horizontal production is exactly the same. It's the moving of those fluids within the reservoir.
So, and that gets to me sort of the fundamental technical questions that we've had presentations here in front of the commission a few times, and I think the earliest one dates back to a Whiting proposal for multiple wells. And I think they were doing perhaps 1.5 mile laterals, but they were going to essentially what they believed to be the appropriate spacing, drill those wells, case those wells, and then come back and complete them. So, which then leaves me, when I look at what you've got with a 90-day staggered, I know if I'm sort of stuck in that box and the belief that, and this does, I mean, granted, there's going to be some time value money issues with this, but I believe notionally around 1/3 of our total well cost is in drilling and casing, and about 2/3 in completion cost. So I guess I'd ask, do you notionally agree with that sort of round assumption on well costs?
Yeah, that's for PDC, that's probably fair. I think when we consider like a 12-month quiet period for say a 10-well program, discounted at 10%, approximate impacts to that could be anywhere from $1.5 to $2 million of PV10, which in our current price environment is probably significant enough to drive that project off the drilling schedule. So I think it's, and again, the discretionary nature of the duration is tied to the permit. So we may put this 10-well package in the budget, run the economics, not count a $1.5 or $2 million PV10 impact, and then submit said permits at a later date, only to run into a duration limit that causes us to remove those wells from the drilling program because of that PV impact.
And certainly, it's, even though it is a much lower number than it used to be,
correct,
it still has an impact on the present value of the property as you go along and look at that. Just, I'm not through yet, so I know you're getting ready to say something.
I'm waiting.
But you could notionally, you could say, all right, I'm going to, and this also ties back to sort of the efficient extraction, is that I would, if I'm stuck with those 90-day limits, and I just did the math, the 18-well pad at 7 days, that's 126 days. So you'd actually have to spend 90 days drilling some of the wells, and come back, finish drilling the wells and case them, and then come back and start your completion operations. But you could do that, rather than saying, and to me, if I would not look at this 90-day staggered as being the most efficient way to develop this if I'm put in that box. I would drill and case all my wells and come back and complete the wells. So I was going to ask your opinion if that's the way you would look at that.
That is our current best management practices. We drill all the wells, case them. If you look at the bottom graph there, using the 9 days to from spud to spud on a well, it takes 148 days for us to drill them. Then we have what I would, is kind of de facto quiet period, where we're not doing 24-hour operations. We're in there building facilities, cleaning up the site, getting ready for the stimulation phase of the operation. So yes, you're absolutely right. We already have a delay there between drilling and completion. The goal is to try to narrow that down.
You could drill that 148 days, put it in sort of your first 2 90-day blocks if you had to. It stretches out the time. I mean, it gets to the time value money concern, because now I've spent all that money, but I don't have any production.
Now, I would say it's not just a technical issue, it's a safety issue. you're talking about me loading up all that equipment, taking it out of the neighborhood, and then loading it all up and moving it back through the neighborhood. And if there's one thing that we hear again and again and again is we don't want more trucks in our neighborhoods. And so, and I think even the trucking association talked about that, every risk times consequence, I believe, was what Commissioner Craig continually refers to. And every time I move in, rig up, I'm increasing the potential for another risk opportunity.
There is more of it. Your biggest safety risk is vehicles on the road, as opposed to, the wellbore construction requirements are pretty strict in the current rules and regs. I think safety is probably the biggest concern is moving it. But notionally, if you had to do that, you said, I'm not going to like it, but I could drill and case my wells in the first 2 90-day blocks and then come back and complete them. And so then you have only the rig moving in and out. And then I don't know how long does it take to frack a 2-mile lateral now in the DJ?
It takes about 4 days for the stimulation operation, and then it takes another 4 days to drill it out. All of those are generally 24-hour operations.
So,
I would have to say notionally, yes, you could do it, but I'd have to say if it was my neighborhood, I don't want you coming back in.
Well, you're going to end up coming in and out again, because if you say 4 days to frack and then 4 days to do the drill, I'd say, okay, I'm going to go frack all the wells. I might be able to get that in 90 days on 18 wells. That's barring, Murphy's Law. Might get in there somewhere. But then you can't flow them back. Presumably you're not allowed, you can't do the clean outs, because you might run out into a limit there because you can't come back and do the clean outs. So then your wells are shut in for a period of time.
I think in that situation, we would just eliminate wells. I think and I would defer to Eric and Dave on this, but my analysis is very similar. At the point you thought you were going to be in that problem, you're going to start eliminating wells because you're not going to leave stuff.
You're not recovering the resource efficiently.
Yeah, it's going to be a serious waste.
Yeah. Fair enough. So this is a question for Mr. Rasmussen. The IT issues that came up, probably wasn't necessarily a surprise, but what are you doing today to mitigate that?
Well, I be very honest with you, it was my response when they reached out to us was there's not an operator in the basin who owns his drilling rig. There's an IT issue on the drilling rig. What we did was notice our drilling contractor out there of these gentlemen's concerns. So it's well out of my pay grade personally, so I'd be probably remiss to speak any detail on it beyond that. But we all lease our rigs on either a pad by pad or a yearly basis. And again, I can't give you more clarity than that.
We all use Payson or something else to get the data.
Yes,
so
sir.
There is that potential risk is there for someone to hack into that system.
Absolutely. And obviously it's something that is being addressed at the level with the drilling contractors and the contractors like the Paysons that are out there doing our automation for us.
I had one more question, but I think I'll hold off on that one.
If I could just jump in on the question you were talking to Mr. McMaster, because BBC has a little different perspective. And if you look at our written material in our pre-hearing statement, if we're doing a 12-well pad at approximately $6 million per, that's a $75 million investment. That's a third of my market capitalization. As I told you last time I was here about the unconventional resource unit, we're already doing controlled flowback. We're not seeing peak production to 5 months out. So we would not be able to drill all 12, wait, and then come back and do that. I mean, the cost of capital and the economic returns get killed by that. So we do them staggered. We do probably add an additional pad. We think we could drill and complete 3 instead of doing 3 4-well pads. We do 4 3-well pads, more surface disturbance. We try to protect the wells and come back in and pressure them up before we fracture the next wells. But we certainly wouldn't do that in the first 9 months of production. We're not going to take the chance that pressuring those wells up or shutting them in that flush period of production that you're ever going to see them come back the way they were. So it's just a killer for project economics.
Is your 6 million number, is that drill and complete?
Yeah, we're running about 5.8 right now.
So it gets back, my question is if how much would you spend if you said, I'm going to change my process and I'm going to drill and case all those wells first and then come back and complete them?
Just do the math. Take a third of that, approximately,
Okay.
24 million. We wouldn't do that. Can't afford to do that.
Commissioner Craig?
I guess this comment is more directed to the attorneys, since you all are most familiar, particularly a certain gentleman here who has been involved and engaged in crafting regulation. I just want to say, wellbore integrity policy for a company, I mean, I think that's great, but I don't think that's my worry right now, is a company that goes so far as to have a wellbore integrity problem. Aren't these regulations more for the companies that maybe aren't quite as advanced as the 4 companies that you presented here? I think we had somebody comment from the citizens group last time that it wasn't Anadarko that was his problem, it was other companies. So regulation is not for the strong links, it's for the weaker link. And that's what we have to respond to. So I guess, technical feasibility and economically practicable to these guys may not be the same throughout the industry.
So let me try to answer that, Commissioner Craig. First of all, the policy that Mr. Roach referred to is a commission policy. And I think maybe the confusion is it's referred to as an offset well policy. You adopted that first in the DJ, you extended it statewide last year. So that is a commission policy that effectively is a kind of a de facto rule, right? You apply that statewide, everybody complies with that. Second, I would say with respect to, I think, the thrust of your question, to me, the real backstop here, and maybe the most important thing the commission did in 2008, was Rule 305E, right? The condition of approval rule. And that broadly authorizes the director to impose conditions of approval on permits. There are no limitations for subject or duration or any kind of specificity beyond. It has to be technically feasible and economically practicable, which comes out of the statute. And the operators bear the burden on that issue. So if an operator wants to contest whether a particular condition is technically feasible and economically practicable, the operator bears that burden under Rule 305E. And that's the rule that's applied whether you're an Anadarko or a PDC or a BBC or a Synergy or anyone else. And I think that's a process that's worked well to this point in time. I think the other backstop you have in the notice and consultation process you're talking about through Rule 305A is this commission. So there is a strong incentive on the part of operators to consult with and to work with local governments. You've heard Mr. Rasmussen from Synergy explain that's been his experience to this point in time. I think it's been the experience of all of these operators, that they routinely work with local governments and find collaborative solutions to these issues. There will be an added incentive that they do so under your proposed Rule 305A, because if they do not, this ultimately becomes a hearing in front of this commission. And so you are the backstop.
And you're implying that no one wants that. Okay, other comments or questions?
And just a comment, I think with what Commissioner Craig brought out, it leaves me mindful that I'm not sure if any of the 4 companies represented here today would instruct your surveyors to trespass on someone's land. So I do have to worry about that also.
Thank you.
No.
Okay. Hearing no other comments or questions, I think if it's okay, Ms. Murphy, we'll recess for lunch.
Chairman.
Oh, I'm sorry.
If I might just respond very briefly to, I understand that was a comment, Commissioner Benton, but I think it raises a little bit broader issue, which is, keep in mind, this is just one source of oversight and relief. And so if you have a surveyor who is acting inappropriately, there are other oversight mechanisms to deal with that situation. Someone referred this morning to a potential breach of a set of covenants homeowner association covenants. Well, if someone is violating their homeowner association covenant, and it clearly applies to not just the surface, but the minerals, there's recourse there, just as there is for any other breach of contract in court, right? If you violate covenants, that's a breach of contract. So keep in mind that this is just one source of oversight.
And one last point on that, Chairman Benton. There is a common law right of ingress and egress to the mineral owner and the lessee that is independent of the statute. So we would need to know a lot more about those facts.
I think, yeah, our AG showed me some of that, so he helped enlighten me along the way.
I'm sorry. I have been informed that we are ready.
Oh, would we like to first hear rebuttal if any parties would like to make it so that we have this entire topic at a
Is that
single
okay,
time?
Rich? Yeah, okay. Yes, ma'am. Opportunity for rebuttal.
I believe Director Lepore may.
Well, no, you're going to rebut?
For 2 minutes.
Okay, and then we have one other one. Kathleen wants to rebut, so
I just want to make a fact correction and make sure we have all the accurate information, but I want to make sure I have enough.
you need to, you probably, Kath, could you come up so we can hear you in the microphone? Some of my colleagues don't hear well.
What did you think?
That's what I was trying to figure out, because I only wanted to correct information.
Okay, go right ahead.
Turn on your mic.
Does Director Lepore want to go first?
No, he does not.
Okay. Thank you. This is going to be my rapid fire response. I just wanted to make the correction that Synergy purchased that plot in Wadley Farms in September of 2013, and the very same day signed a subsurface access agreement with the current operator. At that time, calling that property the Synergy drill site tract and going into detail about how all horizontal wells would be drilled from that location and the details of the plans. So I just wanted that to be on the record for you. Thank you.
Okay, thank you. Director Lepore, would you say 2 minutes?
Or less. Thank you, Mr. Chairman. 2 points on rebuttal. First, Mr. Wanstone's objection to 604C4 language, best available technology. The language that we use in the rule does not change our statutory authority. Whatever language is in there is subject to the statutory authority. If the statutory authority says technically practical and economically feasible, that's what we have to do. So changing that language or putting the other language that Mr. Wanstone wants in there does not change what we can or cannot do, what we can or cannot require operators to do. Second point, the 90-day staged examples, the top example from extraction slide, where allegedly the operator could only drill or complete for 90 days and then stand down for the remainder of the year. I have absolutely no idea where that came from. Nothing, that did not come from staff ever in any way. So that, take it for what it's worth.
I think he actually so much as said that.
He did. I wanted to be sure that you understand that it did not come from staff. We had a very good conversation with Mr. McMaster on these duration limits. He came to the office, met with myself and some staff. Very helpful for us to understand all of these issues. Those assumptions are made-up assumptions. We've had good conversations with Mr. Rasmussen as well, and with Matt Owens, the president of Extraction. The quiet time, the time that's built in there between the drilling and the completion phase on the bottom extraction graph of 60 days, sounds like a good quiet time to me. Maybe that gets stretched out just a little bit. Those are sort of the kinds of things we had in mind when we talked about this. Thank you very much.
But of course, we're not discussing that issue here because it's off the table, although I understand why we are. Okay, anything else, Ms. Murphy?
Seeing none.
Just real quickly, when we come back, then we start over on our list.
Start over where, sir?
Well, our list.
We do. We start with proximate local governments at this
proximate
point in time.
And we
And
go through
staff,
that again. I'm
staff,
just trying
citizens
to
group.
decide if, we'll decide when we come back about exactly what's our timing going to be for the rest of today and then into January. Okay, we'll work on that. Okay. Hearing no objection, we're going to adjourn for lunch and reconvene. Oh my goodness, it's at 1:30. Would that be acceptable to you, Mr. Neslin? Okay, we'll reconvene at 1:30.
You were just waiting for that. You knew he was.
Okay, we will reconvene. I believe we are at the point of considering the proximate local government issue. And if the staff has any time left. I don't know if it's good news or bad news, but the crowd has thinned.
Down at the bottom.
You're trying to get to the slideshow?
So that, yeah.
Overcome. Yes, I go. Good afternoon, Commissioners and Mr. Chairman. Matt Lepore, Director, back to talk about Rule 305A-D, which is meeting with proximate local governments. There's also a requirement to notify proximate local governments. And in our draft rule, proximate local governments were defined as local governments with land use authority within 1,000 feet of a proposed large UMA facility. That distance is one of the things that I know you will hear more about from others who believe it ought to be a greater distance. I'm sure you will also hear from other stakeholders who believe that proximate local governments should stay the heck out of this. That recommendation 17 did not contemplate a role for proximate local governments. I would say to you that expressly that is true. There is no part of recommendation 17 that expressly said local governments should be consulted if they were within a certain distance of a proposed large UMA facility. You may also hear that there's some language in the recommendation that talks about the opportunities for other local governments. I would submit to you that there are lots of ways to read that nebulous language about other local governments. One way might be that that would apply to local governments who do not wish to avail themselves of the consultation process that we are contemplating. So yes, the consultation process is an opt-in kind of process in that we have a rule. If they want to engage in consultation, the operators ask. The local government has the opportunity to say, yes, we'd like to consult. Other local governments can do what we already have in the rules. That's one way to read the other local government language in recommendation 17. Why is proximate local governments in here, consultation, discussion with them if it wasn't part of 17 expressly? It is in here because as we did our outreach meetings in advance of the stakeholder meetings, there was near universal interest from jurisdictions in being able to comment on an application for a large urban mitigation area facility. If a jurisdiction's citizens would potentially be affected by that large urban mitigation area facility. So if you look at the screen, and if you can read the print that I tried to make big enough to read and maybe didn't succeed, we showed you this example during the first day of hearing where the location is being built in Weld County, and all of the homes that constitute the urban mitigation area are in the jurisdiction of Frederick. So we should tell Frederick they don't get to participate. Or maybe not. Maybe we should give them an opportunity to just comment, ask for a meeting with the director and the operator, and let us know what they think about potential best management practices, et cetera. And that's the rule that we drafted. That, again, within 1,000 feet, some will say it should be a distance of a half a mile. Some might say it should be a mile. But within some proximity, even though the site's not being built in your jurisdiction, you should, as a local government designee, local government representative, have the opportunity to say, look, here's some things for you, COGCC, and you, operator, to consider as this facility gets built. Some of the local jurisdictions that supported this concept are Garfield and the West Slope Government Alliance, Brighton City, and Brighton, Adams County, La Plata County, Boulder County, Fort Collins, Thornton, Loveland, and Erie all supported this kind of a role for the local governments. Okay. One thing that has come up in some conversations with a variety of stakeholders is if we notify, if the director schedules a meeting with the proximate local government, perhaps it would be appropriate to notify and invite the local government with land use authority. I throw that out for your consideration. That was something that Weld County has talked about and something that Garfield County has talked about. I wouldn't have any problem adding that kind of language. Probably the most important thing I need to say is that we have been very careful to not give these proximate local governments what everybody calls standing for shorthand. That is the right to compel a hearing on this application or the right to veto in any way the site for the large urban mitigation area facility. So that's what bullet point 4 there says. And I don't think there's much debate about how the rule is written. I think it's been fairly clear to most stakeholders that this doesn't confer standing. Not everybody agrees that they ought not have standing, but I think there's general agreement that our rule doesn't give them standing. I think you might hear from industry that recommendation 14, which didn't get 2/3 majority vote, had a proximate local government type proposal in it. That recommendation granted standing to proximate local government. So I want you to be please mindful of that very different substantive proposal in recommendation 14 that did not garner the 2/3 majority vote. And I will stop there and answer your questions if I can.
Questions for the director? Commissioner Craig.
I just want to say thank you for making the clarification between consultation and giving standing. That discussion was very helpful for me.
Thank you. It is a very important distinction.
Mr. Chairman. Ms. Commissioner Spielman.
Thank you, Mr. Chairman. If this is not helpful, I'll withdraw it, but I wondered if a review by Ms. Murphy of the remaining time might be of interest to not only the commissioners, but attendees. With your permission, Mr. Chairman.
Please.
Thank you.
I have the citizen group as having 7 minutes, 24 seconds remaining. Actan as being out of time. Sierra Club has 15 minutes. Ms. Hall has just over 3 minutes. West Slope governments have about 14 and a half minutes. Adams County, 10:06. Commerce City, 10 minutes. Allied local governments, 36:26. Weld County, 3:51. Industry, 34:11. And there is, OGAP also had reserved its time for the remaining issues section, which is 15 minutes. So
OGAP had reserved for
their time to present during the remaining issues.
Okay, then, citizens group, have any comments? Thank you. ACDAN is out of time with, they may get a little bit extra at closing. Sierra Club, Catherine Hall is not here. West Slope governments. Oh, so nice to see you. How are you, Kirby? It's off now. It's on now.
All right. Kirby Wynn with Garfield County, and more importantly, representing the Western Slope governments, 7 governments. Appreciated the overview that the director provided. We really agree with most of what he had to say about the proximate local governments. We just specifically emphasize the importance of that distinction between a consultation, or in local government parlance, a referral agency role for proximate governments versus having anything that looks like, smells like having standing in the process. Local governments are well-versed in coordinating, communicating with their adjacent or proximate local governments. They have their own processes for that, and for you all to try to administrate that in some different way that looks and acts differently would just really cause a big rat nest of problems, I think, between the governments. So I just want to emphasize that. And we don't really have it'll come up, don't feel too strongly about what sort of a distance or buffer area you might use to identify which proximate local governments might be notified about a process. And we most strongly emphasize, no matter what you do, is that the local government with jurisdiction is at all meetings and invited to participate where you're going to bring in, or if a proximate local government is going to ask the director to consult with them and talk about BMPs, the local government jurisdiction absolutely should just be there at the table. That's it.
Thank you. Questions? Thank you very much. Adams County, Commerce City. Allied. Oop.
Good afternoon, Commissioners. My name is Jennifer Rutter, and I'm the LGD and Environmental Analyst for Adams County. I just wanted to clarify something that had been brought up by the industry group earlier. Synergy does not have an executed MOU with the county. A signed MOU was submitted in the spring, but was never executed by our Board of County Commissioners. So onto the proximate local government topic. Adams County recommends that the notification and consultation radius for proximate local governments should be 1/2 mile. This is consistent with our current practices at Adams County and reflects the potential area of impact for a large facility that it could have on road networks, water systems, and other things. The impacts of large facilities cross political boundaries, including noise, light, and air quality. Given the nature of these impacts, it is appropriate to allow a role for approximate jurisdictions that do not have land use authority, but may be affected nonetheless. The closest first responders to an incident could be those from an adjacent jurisdiction. They should be informed and have the opportunity to coordinate with operators to better prepare for emergencies. Additionally, since the operator is required to identify and consider alternative locations, it can only be beneficial to bring in proximate local governments into the process early. The consultation with proximate local governments will allow for the collection of additional information regarding community concerns, which would benefit all parties, including the industry. Finally, large UMA facilities are so infrequent that this additional consultation would not pose a great burden to them, impose a great burden upon the operator. Local governments within a half mile should have the opportunity for a conversation with the operator that decides to develop a large facility in a residential neighborhood. Thank you.
Question? Commissioner Benton.
I guess it's a logistics question. How do you find out what, say we use quarter mile, half mile, whatever it is, how do you actually find out what proximate local governments should be notified? I mean, physically, where's the list of people? How is that done?
Well, I use a GIS database, so I can look at the proposed site location and then go through and find the half mile radius, and then whatever other adjacent jurisdiction is nearby, I notify them.
And that's in that database, so you can just say, okay, it's going to tell me all the local governments that are in there?
I do it visually. We don't really have a database necessarily, but we have, a lot of proximate local governments, and I can see them all on our map.
Okay.
You got layers.
Yeah, layers.
Director.
Just if I may quickly, how does it work? Not very well. Well, that one, a little much better. All of that information, Commissioner Benton, is on the COGCC website. You could plug in the location, do a radius of any distance you want, turn on the layers for the local governments, and you would see everybody.
Are there questions?
I think,
Thank you very much.
That rare occasion that you do.
No, I already went. I did that. Commerce City.
There you go.
There.
Good afternoon. My name is Chris Kramer. I'm the local government designee and community development director for the city of Commerce City. I'm here to talk to you specifically about this issue in particular because our city council is interested in this issue. They are interested in everything that's going on today, but this one in particular stands out to them. I want to talk to you for a few minutes about our context to hopefully provide some insight to you about why this requirement would be a step in the right direction. I think our condition may be present throughout the state, maybe not everywhere, but certainly enough times to warrant the consideration of this type of recommendation. It should be noted, I'll just go ahead and not bury the lead. We are recommending, we do see Adams County recommendation increase the distance to half mile, and we raise them another half mile to go to a full mile. That is Commerce City's recommendation. And let me tell you why. If you're familiar at all with the Adams County geography and Commerce City, it's a community that's been growing steadily over the past couple of decades, really, and it's growing out towards Denver International Airport. There are some barriers to growth on the south, which is the Rocky Mountain Arsenal National Wildlife Refuge, into the north, which is Bar Lake and Brighton. So as that growth continues east, it's eventually going to bump up against Denver International Airport. And as you may have seen in the Denver Post, there's quite a bit of discussion about development in the airport area. The Aerotropolis project is underway. Voters from both Adams County and Denver recently passed so some measures that will hopefully promote growth in that area. We are planning for that growth. We are promoting that growth. What we are asking is that we simply have the opportunity to include this type of development within our planning processes. The interesting thing is, through a series of intergovernmental agreements that we've signed with some surrounding jurisdictions, the area that is in this future growth area, leading out towards the airport, we know that if it does, when it needs services, urban services, water, sewer, et cetera, urban level services, they will need to incorporate. When they incorporate, because of these IGAs that are in place, they will incorporate to Commerce City. So we better know that the growth related to the airport will occur. We know that when it does occur, it will need to annex. And when it annexes, we know it will need to be annexed into Commerce City. So any oil and gas development that occurs in this area, while it may not be in city boundaries today, it will certainly be an issue that we will have to deal with, whether it's annexed today or not. So therefore, we are, our city council is requesting that the commission take this recommendation and actually increase the distance requirement up to 1,000 feet. So I am available for any questions you may have. I'm sorry, not 1,000 feet. I read that. From 1,000 feet to a full mile. Apparently, it's already sticking. Good.
It's stuck. Okay, any questions?
So Commerce City has an IGA with Denver County?
We have an IGA with Aurora, Thornton, Brighton, and Adams County.
So why couldn't this area of businesses coming in, which is basically what it is, development, why can't you handle that under those IGAs rather than under a full rule?
That's a good question. And if those, the ones that are primarily in question that would eventually be incorporated into Commerce City are in unincorporated Adams County currently. And we certainly hope that we would receive a referral from Adams County and their IGA, who just spoke. However, what we think the benefit of this proposed rule would be is the opportunity to meet directly, have a seat at the table with the operator and the staff. The way it exists now, there is no obligation by that county to provide us a seat at the table or even notify us. I do think we have a good relationship, but there's absolutely no guarantees that any of that will happen.
I would think you'd be able to modify your IGA and get that included in there.
We do not have an IGA concerning these types of notifications. It's simply a referral process that is no different than any other land use application that we have. So we don't necessarily have an IGA that lays out that type of communication. It just lays out where properties can be annexed.
Because in Weld County, we do have that. Being the mayor of Fort Lupton, we got an IGA with the county, and anything within our 3 mile comes as a referral to the city. So I'm just wondering why you guys can't do that instead of having a rulemaking.
Should the county not agree with our proposed ideas or recommendations, we would still like to have the opportunity for those to be heard. And going through them as the LGD, you're not always ensured that the local jurisdiction's views are expressly transmitted, if that makes sense, because you're sort of beholden to the LGD at that point.
Okay.
Are you proposing upping it to 3 miles?
Proposing to get rid of it.
Okay, any other questions? Thank you. We probably are at allied local governments. Matt, that's too fast. I can't keep.
And you conclude.
So, allied local governments, Matt Sura, and today I'm speaking just on behalf of allied local governments. We have Brighton, City of Brighton was called to other duties today, and so we have pressed into service Tori Jarvis, who has been representing Erie and Northwest Cog. We understand that she's out of time, but she's going to use our time on this issue and be our witness. Thank you.
Great.
Thank you, Matt. Thank you, Chair Compton and commissioners. Again, for the record, I'm Tori Jarvis representing Erie and Northwest COG in this rulemaking. And we very much appreciate the allied local governments allowing us to spend a little time explaining the background because like you heard from Commerce City, this is an issue that is important to, in particular to the town of Erie. The town of Erie and Northwest COG both support notice to proximate local governments remaining in the rule and recommend 1 mile as a recommend notice to local governments within 1 mile of a proposed large-scale facility in an urban mitigation area. And we also really appreciate the staff or the commission staff, including proximate local governments in this rulemaking, because as you've already heard a little bit already, proximate local governments are definitely most certainly affected by oil and gas development in neighboring jurisdictions. And we wanted to provide just a few examples of how those adjacent local governments may be impacted. As you just heard from Adams County, one of the most obvious examples is that trucks and equipment will be traveling on roads owned or maintained by adjacent local governments to get to that proposed facility. Second, proximate local governments that are only 1 mile away are likely to be first responders in the event of an accident. And so early notice will help ensure operators, the commission, and all involved local governments are all working together to prepare as early as possible in the process. Neighboring local governments may be asked to supply water for drilling and fracturing. Alternative locations may be in a neighboring jurisdiction, so having that input would be important. And finally, in many places on the Front Range, like in Erie, growth is occurring rapidly and is often concentrated near jurisdictional boundaries. And so early engagement with proximate local governments can help reduce those conflicts. Understanding and beginning to address these impacts should happen as soon as possible, as it's currently in this rule. In our experience, operators also want to know and begin to address the impacts and concerns to neighbors, including neighboring local governments, as soon as possible. This rule helps the operator to understand those concerns from the outset, just as the rule helps the commission and the director to start to do the same. Of course, operators in the adjacent local governments are free to do this already, but we see a central purpose of this rulemaking, as we actually said earlier, to be formalizing that coordination between local governments, operators, and the COGCC to best include all affected interests. And including proximate local governments is just another way to do this. So it really does get to the basic purpose of the rule as we see it. We also understand there's been a recommendation that the local government with land use authority be expressly included in these meetings. And we are totally fine with that and agree with that. That makes sense. We would also add that giving, as you've heard by several people, Director Lepore included, that giving adjacent local governments early notice and opportunity to comment does not give them any additional standing, nor does it give them any additional land use authority. It simply requires them to be notified and ask the director to consider those comments. We also note that providing notice to local governments within 1 mile of an operation is still very conservative. Erie and Northwest COG both are recommended in our pre-hearing statement that all adjacent local governments should be included because of all the impacts to neighboring local governments that you've heard from us and from Commerce City and Adams County and Garfield County. There are certainly impacts to local governments outside of a mile from the operation, but we compromised in working with the allied local governments and agree with our allied local governments that recommending a mile would be a productive step forward. Broomfield, Fort Collins, Longmont, Boulder County, and La Plata County all joined Erie and Northwest COG in our pre-hearing response. And you can see the language that we recommended, and it's actually just that short piece number 2 that's up on your screen. So it's a very small change that we would recommend. And then you've also heard the same thing from Commerce City, similar language, but a little bit smaller from Adams County. And then I also wanted to point out Brighton included a slide, since they weren't able to be here, but they support the 1 mile distance as well, and provided the slide that shows their facilities facilities that were proposed within a mile of their jurisdictional boundary within the past 2 years. And then I also understand that Loveland is supportive of the 1 mile distance. And with that, I'm happy to answer any questions. Thank you.
Questions? If it's not too lengthy, Northwest COG includes what governments?
It includes all municipalities in Grand, Summit, Eagle, and Pickens counties. So neighboring Garfield, but not any in Garfield County. And then Gunnison County and Park County are also members, but not the municipalities, except Crested Butte.
Thank you. No questions? Thank you. Matt, do you have some other? Thank you very much. I think Weld County has already given us their input earlier today on this issue. So we're up to industry.
Good afternoon, Commissioners. Dave Neslin speaking on behalf of the industry. Picasso said that art is the elimination of the unnecessary. And we're going to urge you to be artful here. By its terms, Recommendation 17 limits notice and consultation to the local government with land use jurisdiction over the location. That's what the task force considered necessary. And it's consistent with your existing regulations, which focus on the local government with land use jurisdiction. Proximate local governments aren't mentioned. The recommendation doesn't contemplate any role for them. Instead, it states, and we've excerpted it in this slide, that other local governments, which would include proximate local governments, may continue to use the current local government designee comment, permit, condition, and hearing process. That is, they must rely on their existing rights to submit comments and recommend conditions under Rule 305 and to participate in hearings that are brought by other parties under Rules 509 and 510. This limitation is appropriate for the reasons stated by Weld County, which has jurisdiction over about 80% of the wells started this year and opposes any role for proximate local governments. As Weld County's explained, expanding the notice and consultation process to proximate local governments will confuse their role, will promote interjurisdictional conflict, and will erode the authority of the local government with actual jurisdiction. Garfield County accounts for most of the other well starts this year, and they generally agree with the points made by Weld. If a proximate local government seeks additional notice and consultation opportunities, then it should obtain them from the local government with local land use authority through an intergovernmental agreement under CRS 29-1-203, as Commissioner Holton suggested. Many of the local government parties have experience with those agreements according to their pre-hearing statements. This will help to avoid any jurisdictional infringement or conflict. So we're not contending that proximate local governments should be ignored, but they should continue to rely upon their existing rights as contemplated by the task force, or they should negotiate an intergovernmental agreement with their neighbors, as many have previously done. Now, several of the local governments explained concern about cross-boundary issues. I've heard no or seen no persuasive evidence that those issues are significant here in the oil and gas context. And I would suggest that this is an artifact or a result of living in a state with 64 counties and 271 municipalities. There will always be cross-jurisdictional impacts with respect to all different kinds of economic activity. Again, for these reasons, we would suggest that the proximate local government provisions be stricken. Thank you. I'd be happy to answer any questions.
Questions?
I have one additional point to add. In reality and practice, when you are looking at the proposed rule for proximate local government, when operators are working with the local government where the situs of the property is located to determine a final location, an operator may not know what proximate local government to notice. I mean, they may not know what proximate local government may be within 1,000 foot of an alternative site or a proposed location. And so we've always from day one said we need consistency, certainty, and clarity. And if they're going in and having an alternative analysis with potentially multiple sites, there's no potential final location to notice from. And that is the reality and practice that we've heard from Ashley Caccioloni and Kim Mendoza-Cook, who testified as to what happens when they actually go and do these notices and the process and how it all should work. Again, with that, we maintain the position from day one that proximate local government notice and consultation is outside the four corners of the recommendation. And we support the task force, the unanimous vote of the task force, Weld County and Garfield County's position that the proximate local government is not necessary and was not contemplated by the recommendation. Thank you.
Questions for Ms. Joseph?
Yeah, Mr. Chair.
Commissioner Allward.
Thank you, Mr. Chair. Currently, aren't operators required to give notice to individuals who reside within 500 feet of the proposed location?
Under Rule 305A, there is a pre-application notice. So no less than 30 days prior to the time a Form 2A is filed with the commission, there is notice that goes to surface owners, local government designees, and then folks within 1,000 feet in the buffer zone of that notice.
So presumably you know where those people live, what jurisdiction they're in.
Well, in this context, you may not, because this is before you have a final location. In that context, you already have a final location under Rule 305a. So there is a difference.
All right, thank you.
When you consider the potential size of the area, and let's say it stays at 1,000 feet, I have a well pad, and it occurs to me that within that, I would just say that well pad's 2 acres. How difficult is it? I mean, we just got through saying it's all there in the COGCC database that you can just use the layers to determine who the local governments are.
And
how difficult is that?
Well, I think that comes down to where you are in basically the site analysis. Because what's being asked in this when you're developing a large UMA facility is provide notice and consultation to not only the local government where the site is located, but also approximate local government. And you have not finalized the location yet. So you may have a pad and in a site that you can draw your 1,000 feet around, but in certain areas, even in Weld County, and I don't recall if Mr. Swain testified to this or not, but you could have potentially 5 proximate local governments within that area, depending on where you are. And so we're not saying it's hard to do, but there's some certainty that needs to come into that. And I mean, our underlying position, sorry, but is it's outside the 4 corners of the recommendation. So.
But at my location and my well location, specific well location is going to be inside that pad somewhere. And I really think that if I move it 100 feet this way or 50 feet that way for the specific, if I GPS location of that well site and that well bore, I'm going to have the same proximate local governments. I mean, there may be a few occasions when it's different, but within that 2 acre well pad, I would bet that 98% of the locations, any potential location in that pad are going to have the same proximate local governments.
And I don't think that we disagree with that. I think that there's a certainty that needs to go along with it. And that certainty comes from the point is that at least at this point, you don't have a final location. And there's, the whole purpose of this exercise and this rulemaking is to work with those local governments where the situs of the property is located to ensure that you have a final location determined as part of this analysis. So, and I understand exactly what you're saying. I think there's just clarification that's necessary.
If I could add briefly to that, additionally and independently, if an adjacent or proximate local government wants to participate in additional notice and comment, they want to serve as a referral agency, they can enter into an intergovernmental agreement, as Commissioner Holton suggested. Those types of agreements are ubiquitous. I think every local government party here is a party to such agreements. They can also participate through their existing rights under Rule 305 and Rule 604 with respect to providing input, comments, recommending conditions. If a hearing is requested, they can participate, they can intervene in, seek to intervene in and participate in such a hearing.
So notionally, because I'm not, Commissioner Holton knows a lot about it. I don't. Being an engineer, I'm not all that familiar with that, with the IGAs, but so it would lead me to believe that if I'm concerned about it, if I'm, for example, Boulder County, and I'm worried about what Weld County is going to do, I'd go do an IGA with Weld County, and it says anytime it's, if you're doing anything that says 1,000 feet from the county line, you have to notify me. That's the avenue you could take.
Yeah, and that's contractual too. I mean, that's going to be better than what we're trying to introduce as a rulemaking. This is, right now with what we're doing, they're just going to be able to comment. But the IGAs that I have with, I'm working on one with Brighton right now. We've got one with Platteville. We're working with Dacono and eventually Frederick and Firestone. But those are contractual obligations that we have to meet. I mean, that's going to be a lot stronger than what we're getting here.
They are anticipated and authorized by specific state statute, and they will also define the respective roles of the local governments to avoid any misunderstanding or jurisdictional conflict as to how those roles align.
Thank you.
Just for clarification, if I'm a government and I have an IGA with local adjacent or proximate governments, and in that IGA, we have an agreement that anytime there's going to be development in our land use authority area, we are required to notify. Then a company comes in as a proposal in my area, I'm required to notify, and industry's fine with that.
Yeah, I mean, that's the existing process, Commissioner, not just with respect to this industry, but many industries.
Okay, thank you.
That's the comment, and that Commissioner Hallward brought up, was that there's a presumption that you could actually execute the IGA between the two local governments. Is there and maybe I'm missing this, is there a specific definition for a local government, sort of how small an entity that could be?
No. Deputy Attorney General Spall was beating me to the statute. I'd have to check the statute, Commissioner. I would note that, certainly counties and municipalities, I believe, would be included. And I think there are 271 municipalities of various sizes across the state today.
It would not extend then to water districts, ditch companies, and so on and so on.
What I was trying to get to.
Would not.
Would not.
May I clarify? Local government is a defined term in our rules in the 100 series. There are certain types of special districts that are included, so.
We just changed that a little bit, didn't we?
It is, I believe, in recommendation 20.
Okay.
A lot of districts can enter into IGAs. Not just incorporated towns and cities.
And as far as you're concerned, industry, if I have this IGA and you're proposing a development in my area, and my agreement is that whenever this happens, I'm going to call in my neighbors, so we're all involved in the process. That's okay.
Yeah, I think that is. Commissioner Bitton, one thing just to address about what if you don't have an IGA. Proximate local governments absolutely are, they already have processes in place to address the concerns that basically this rule is getting at. They can utilize the recommendation expert, the local government designee comment, permit, condition, and hearing process. That's with the state. They have other types of comment, and they can pick up the phone and talk to the adjoining local jurisdiction, but they also get notices, Mr. Swain from Will County testified to, of those local permit processes. So if, just because this isn't in this rule, if that's where this commission decides to go, that does not mean that proximate local governments have nowhere to go. They actually have a lot of avenues to provide comments to permits such as these.
And Commissioner Compton, again, in response to your question, I think the answer is yes, and that occurs today. And industry is fine with that today.
Okay, other questions?
Thank you.
Before we depart, very briefly, I think the industry and the allied local governments both would like to address you at an appropriate time this afternoon about closing arguments and when closing arguments will occur. We don't need to do that right now, whenever you would like to take up that issue, but we would like to be heard on when they will occur.
While you're seated there, why don't we just, is that okay to take that up now, colleagues? I think, and again, y'all jump in here quickly. We're sort of thinking that we have rulemaking dates set up in January. And we're sort of thinking that we're going to maybe sort of shoot for that time for closing arguments, not close the record between now and then, just in case, and then try to hear those then, and then move into deliberation. That's kind of what we're thinking. Is that what we are thinking? Yes, that's what we're thinking.
Well, I think the industry would strongly support that. We believe that that is the best way forward. We would be concerned if we were going to present closing arguments now, and then you would not begin deliberating for maybe 6 weeks. That's a long passage of time. And we think it'll be most helpful to you if we present our closing arguments when you deliberate. And we also think we've been through a couple days of hearing. We've had another robust day of hearing today with some testimony from all parties on these issues, allowing the dust to settle a little bit and allowing the parties to think through their closings will let us do a better job for you. I think we'll be able to present closing that are of more assistance to you as you take up these issues. And they're complicated issues, as we've been discussing. Now, I'll let Mr. Surup speak for the allied local governments.
And I can read between the lines. You're concerned for my memory, and I understand that. Mr. Zurich.
Oh, just for the record, that did come from industry. So Dave and I have talked about this, and allied local governments agree that we prefer to wait until January when you're deliberating to address with, some final comments.
Any other parties care to comment on that issue?
See, Mr. Chairman, you're already bringing the parties together.
I hope this time is getting charged to industry right now.
Commissioner King.
Mr. Chairman, I just want to make sure that it kind of feels like we may be headed towards staff maybe potentially deciding to submit or distribute another draft rule at some point before we reconvene on the 25th. I think we need to make sure that expectations are clear right now about what will happen. My feeling is that we will probably need to accept any 5-page written submittals, comments on that draft. We need to leave that door open, but I would also recommend, subject to the rest of the commission agreeing, that we don't reopen a whole new round of oral argument at that point.
That makes sense to me. Director, you anticipate you and staff making, I'm going to use that word, substantive changes or tweaks or some changes?
I think that we likely will have a draft out. I like the term reconciliation draft, optimistically. And I think the last pre-hearing order did say that if we were to do that, the parties would have the opportunity to file up to 5 pages to respond to the new changes. So that's where we are.
That sounds reasonable. Okay. Okay,
Chairman,
Ms. Murphy.
I just want to clarify. So we're looking at having the fourth day of hearing on Monday, January 25th. As soon as we know the location, I suspect it will be here, but we will be working towards finalizing that. And I would ask that the commissioners reserve both Tuesday and Wednesday of following, no, I know you're out, Ms. Craig, but to conduct other commission business on the 26th and 27th. And those
3 days?
I would like to reserve it. We've moved some hearing matters to accommodate the rulemaking hearing this month. And at some point we have to get caught up. So,
Okay, then we'll have that final day of hearing on the 25th.
mhm.
You're asking us to reserve 26th and 27th. And then between now and then, you'll see if you need the 27th.
Absolutely. And I'll be in constant communication with you all as ever. And so then the goal today would be to get through both recommendation 20 and any effective date testimony and reserve remaining issues for the 25th. Is that fair? Okay.
Yes, ma'am.
Commissioner Compton?
Yes, sir.
I guess I have a little bit of reservation in that there are a number of parties, including allied local governments, that didn't anticipate that there was going to be a new draft in their allocation of time on these different issues, and would like to keep that open in case allied local governments and others feel that they don't have adequate time to be able to present their arguments or there are questions about their 5-page summary. We'd like to have one last chance to be able to engage on this new draft and leaving it only to those new issues that are raised in that new draft.
Okay, that sounds reasonable to me. Am I off base? Hearing officer?
Sitting in the shoes of the hearing officer currently, if parties would like additional time, if they can ask for that time in anything that they file. And then it's going to be a question that we would probably put to you as the commission as to how much time you want to give everybody to address these changes. Is that?
After we have seen what the changes are, and we've seen the humongous 5-page response,
Would it be safe to assume that, I think as you said it, we call them reconciliatory changes, that it's not going to be a whole lot they're left to respond to if the groups are only left to respond to specific changes?
and you anticipate that document being out certainly by
January 24th?
I was thinking December 24th, but.
Ho, ho, ho.
Well, if there was adequate time, not only do I forget, I'm a slow reader, so a week, 10 days before the hearing? I think, Matt, we could work something out there.
Thank you so much. Appreciate it.
Mr.
Okay.
Chairman,
Mr. Lepore.
I do, there are 72 parties. They've done a nice job of grouping together and working, to present materials as groups. But 5 minutes per closing adds up pretty quickly, depending on how many parties want to make a closing statement. And you add on top of that potentially some additional time to address additional substantive issues. We just have to keep track and be mindful of the time that you might want to deliberate, ask follow-up questions, et cetera, in addition to these continued presentations by parties.
So we have 11 party groups. And you would anticipate, for example, under industry, Anadarko is going to want some time, and Noble's going to want some time, and Mobile's going to And instead of industry getting a particular period of time?
In addition to the party groups, we have parties that presented to you in November that did not group. So all the parties are afforded the same rights.
I understand. Okay, I've forgotten it. Okay. Okay, we'll try our darndest to make that work. We may have, the commission itself may have to work beyond sunset on that day.
That's earlier than 5. That sounds good.
I think he said beyond, with no specific time limit.
Okay, anything else from y'all?
30 seconds is beyond.
Chairman, before we jump to the next topic, I wanted to make sure we don't have any rebuttal.
I can't imagine there being any, but we'll go ahead and grant some time.
Well,
Here comes Mr. Custer, maybe. Kirby, did you have some rebuttal?
Kirby Wynn, representing the Western Slope governments. Just a little clarity. I listened to what the industry had to say, and maybe they said it right, but I doubt they said it for the right reason. So, for one, they said that Garfield County didn't think there's any proximate local government needed in the process, and they're kind of right. But the Western Slope governments did believe that it's beyond what the state needs to do to really try to administrate this proximate government process. But what we really said, and you'll find it in our written documents, and I'll reiterate it, proximate local government should serve in a referral capacity and not as a consulting government in a local land use process that's beyond their jurisdictional authority. And by referral, I just want to be very clear, and this is why I'm here, to us and to local governments, a referral agency means that the local jurisdiction manages the notifications of who and what gets noticed and why and how the comments are received. And the comments are generally received to the local government, not to a state agency or a federal agency or what have you. So I want to be very clear, that's what we're talking about, is let the local governments do what they do. You heard the talk, and you yourselves are aware of like IGAs between governments. Garfield County as one example of one Western Slope government. There's others. We have a 2-mile buffer IGA with our local governments within Garfield County, but we manage at a local level. We don't need the state or want the state to try to administrate something like that. That's our expertise and our authority. That's it.
Any questions? Thank you. Come on down.
This is Ben Perlman, County Attorney for Boulder County. Just wanted to quickly say that I appreciate the interest in IGAs. They're something that we have used in our county to great effect on a number of different ways for different purposes. My sense is that it's a great solution when it works, but they do require governments to agree to contract and to decide that's how they're going to resolve any differences they have. I think it's when you don't have that, when you don't have a good working relationship, that it's most important that you have some other way of having these issues come out. And I can say from personal experience that I see it as very unlikely that Boulder County and Weld County would enter into this kind of IGA. Not because, well, for all the reasons that I think that speak to the difference in philosophies between how we address issues. And you can be on one side of that or the other, but the fact is that you're not likely to see this resolved through IGAs between at least those two parties. And I imagine that when you look around the rest of the state, that you see that elsewhere as well. As to the lack of evidence of any problems that this issue, local proximate government is trying to resolve, I can guarantee you that we've already seen lots of development, oil and gas just on the other side of our boundary with Weld County, and that we expect that that will continue, and that we have lots of agitated residents of our county that are concerned about this. And so this is certainly an issue, and we certainly hope that you will use this as one additional tool for us to try to smooth out issues that affect people in and around oil and gas development. Thanks.
A quick question. So currently, if say it was 1,000-foot notification boundary, you have no mechanism now to try to work that out. That's what I'm understanding. Is that true?
Well, I mean, there's lots of informal options. We can try to talk to industry. We can try to talk to other local governments, but there's nothing that actually requires anybody to sit down. And I think that's what this does. It just says, hey, we are going to be drilling here. There are going to be impacts, and we think those impacts are felt, beyond 1,000 feet. I think a mile is a better line of demarcation, and this gives that opportunity to happen formally. It doesn't mean that there's going to be any particular result that comes of it, but I, like many people, believe that when you actually do sit down in a room and you say, hey, this is what I'm concerned about. These kinds of locations are tough on us for these reasons. Are there other options, or what can we do? A lot of good things happen, even among parties that don't necessarily see eye to eye on a lot of things. So I think that there's some real value that can come of it. And frankly, it's not that onerous provision. It's just to sit down and talk.
Thank you. Question, Director King.
So, Counselor, how do you respond to the concern that because of the activity that's occurring in Weld and Boulder's temporary prohibition on oil and gas, it creates this incongruity where you get to go to Weld and have discussions about what's going on in their jurisdiction, but the inverse is not also true? How do you reconcile that?
Well, it's not currently true. I think we all recognize that we're not going to have a moratorium in Boulder County forever. And at that point, we would expect that when we're doing things that are close to Weld County, that they should come be part of the process, and we should consider their issues as well.
But you want to have this authority before the moratorium in Boulder is lifted?
Certainly.
Okay.
Commissioner Craig.
No, let him go first.
Apparently, you get to go first.
Thank you. Have Weld County and Boulder County had any discussions about an IGA?
I am not aware of any specific discussions, but those are the kinds of things that often happen between elected officials that don't involve me or my staff until the last minute.
So it's just an assumption that you wouldn't be able to get along.
I was a Boulder County Commissioner for 7 years, and in the first year, one of the first things that I did was I said, we have to go talk to Weld County. There's a lot of bad blood. We're having cross-jurisdictional issues. So we got in the car and we drove to Weld County and we had dinner and we talked about I don't know, a dozen things that we thought we probably could work together on. And the answer from Weld County was no on all but one of them, which was exceedingly minor and really wasn't that useful. And so I think it's the kind of thing that is tried from time to time by various people, and it probably should be tried again until we're successful. But there's just a lot of differences in our approach, and that leads me to believe that there's not likely to be
a low probability then.
I would say very much so. Yeah.
Although it occurs to me is that it seems like there's, being as Weld County and Garfield County both are not, they want this in here, but I think at a level that is sort of managed at the local government level, not at the state level, that perhaps Weld County would have more of an incentive to do an IGA or do some sort of an agreement between Weld County and Boulder County now. It's not a question, it's just a comment. I mean, you don't have to respond.
Okay, Commissioner Craig, you can't put it off any longer.
I just was going to say, I feel very uncomfortable trying to be the middleman in something that ought to be managed at the local level. I just put that out there.
Okay, thank you very much. Registration with the local jurisdiction and information provided to LGD. Is that correct? And does the staff have a comment on this?
you taking me there? Yes. Now, how did you do this before? Mr. Chairman, I think I'm in an awkward position here. I think that the hearing officer thinks that I'm out of time. So I guess I am throwing myself on the mercy of the chairman and commission. I have 2 pages of notes and about 8 slides to talk about recommendation 20. I'll do my very best to be brief and concise, if you will indulge me.
You are indulged.
Thank you very much.
You are being indulged.
Thank you. First time for everything. Recommendation number 20 was a recommendation to include future oil and gas drilling and production facilities in existing local comprehensive planning processes. I would tell you that I think one of the key themes of the task force work was to try and do a better job coordinating between the interested parties, primarily the operators, the local governments, and COGCC, the local governments representing their citizens, in planning ahead. How can we plan ahead? How can we try to avoid developing a subdivision on top of mineral estate interests without anybody being aware and talking and planning that through? The key elements of the recommendation were that beginning on a date certain, all operators registered with COGCC would also register with the LGD of each municipality. I want to point that out, in which it has current or planned oil and gas operations. Upon the request of the municipal LGD, the operator shall provide a certain set of information. So again, note that this recommendation was limited to municipalities, and that it was upon the request of the municipal local government that information would be provided. Not going to spend much time here on what was asked to be provided. It's in the recommendation, it's in our rules, it's pretty self-evident to some extent. The tricky part here was the last phrase. Operators should provide information about the wells they intended to drill, based on the operator's internal analysis of reserves classified as proved undeveloped for SEC reporting purposes. Sort of after the task force concluded its business and we sat down and looked at this, it sort of the light bulb went on that only public companies have proved undeveloped reserves, which raised a question about whether the intent was to limit this reporting requirement to publicly traded companies. Staff doesn't think that that fulfills the spirit of the recommendation. And I think, I hope I'm not wrong about this, but I think that for the most part, the industry stakeholders are aligned now that these reporting obligations should apply equally to privately held companies and publicly held companies, but they can certainly speak to that. The other sort of key issue here that came up in our outreach meetings was whether this requirement should be limited to municipalities or should also include counties. Many counties with whom we met on our outreach meetings felt very strongly that it should apply to counties. Weld County does not feel that way. Garfield County does not feel that way, and I'll let everyone else speak for themselves. It's interesting to look at the rationale that the author of Recommendation 20 put forward. In his rationale, he said that the planning is often disjointed and not coordinated with local governments, most acutely in municipalities. Accordingly, when oil and gas development comes to a municipality, it can result in conflict with the existing community goals and aspirations. This proposal is to recommend the framework which will facilitate incorporation of drilling plans into municipal comprehensive plans. Again, on our outreach meetings, I think there was a pretty strong opinion from many counties that same rationale does apply to the counties. So staff's draft is limited to municipalities, and in terms of how we defined the jurisdictions that this would affect, it does exclude counties, but I expect you'll hear from some that think that that should not be the case. If you exclude counties, as an alternative proposal, staff thought it might make sense to include the growth management areas of the municipalities. So there are lots of people in this room who can explain to you the growth management areas better than I, but my understanding is that the municipalities do have areas that extend beyond their boundaries where they do anticipate growth in the future that would happen through annexation, that those areas are easily identifiable today, and that it might make sense in this planning process that the operators would provide information, the information that recommendation 20 calls for, in those growth management areas as well. So not necessarily the counties, but for the municipalities' growth management areas. And that way those plans would extend into what today are unincorporated county lands, but those lands which a local municipality has said, hey, this will be ours in the future, and we have plans to do things here. So that seemed to us a fair and reasonable sort of compromise position for you to consider with respect to the requirement of providing information to those municipalities. The one point I want to make on what information should be provided. So again, the recommendation lists some specific things, and we've included those things. But in our conversations, this is really about how do we, again, give these municipalities a heads up that oil and gas development is planned, and is everyone accounting for how that best might happen? And from staff's point of view, kind of one of the earliest indicators that oil and gas development is somewhat imminent are our drilling and our spacing orders and our pooling orders, right? When an operator comes to us and wants to space lands and then subsequently or concurrently pool those lands, we're pretty sure they're planning to drill in the next 2 years anyway, or 3 for the Form 2A approvals. So our thought was to add that, and I think you may hear a suggestion that would be a good substitute for one of the other things of sort of planned but not yet permitted drilling. Providing these spacing and drilling orders to the municipalities, I think would be a great way to give them a heads up. Very specific location, reasonable time frame, close enough, within this mile, or as we space 320 acres, 640 acres, 1,280 acres. Somebody's got a near-term plan to develop the minerals here. So I think just food for thought. I don't think I need to say anything else. I would be happy to answer questions.
Questions for the director? Commissioner Benton.
So notionally, what you're asking is we have to give you a 5-year plan of what we're going to do.
Not me, but the municipalities, yes.
Okay, sorry, the municipalities. You're asking us to. The rule will say that we have to supply the municipalities with a 5-year plan.
Yes.
So
The wells, the number, I believe the request is a good faith estimate of the number of wells that you intend to drill in the next 5 years in the jurisdiction. Number, that's all.
the number of wells.
The number of wells.
Thinking back to recent events in the last year in which a number of companies had some fairly substantial budgets, and those are much less substantial. And they would have submitted a fairly large number of wells in 2014. How do you address that within the context of this proposed rule? Changes to your plans.
Sure. So the recommendation contemplated and our rule reflects that those estimates provided by operators are to be treated as estimates, subject to change at any time at the operator's sole discretion. Our language, the staff's proposed language, says that those estimates are to be based upon reasonable business judgment, based on information known to the operator at the date of the request or at the time the estimates are submitted, and that those estimates are subject to change at any time at the operator's sole discretion. So there was a lot of conversation about how much reliance to put on those and so forth and so on. I see these as a means, that was scary. I see these as a way to mostly start conversations.
That's at the request of the municipality.
Yes, sir, Mr. Chairman, that's correct.
Other questions? Thank you, Director.
Thank you.
Citizens Group. No comment. Dan's a little short on time. Sierra Club, keeping their powder dry. Catherine Hall. West Slope Governments.
Thank you, Commissioners. Kirby Wynn, representing the Western Slope Governments. As I believe you heard the Director mention, many of the counties where the oil and gas development occur do not think that counties should be included in this registration process. When you include Weld County, which we know agrees with us, and the 5 counties that I'm representing today, 70% of the wells drilled in Colorado, those county areas, do not think that counties need to be included in this. That's it.
Question? Thank you, Mr. Wynn. Okay. Adams County.
Good afternoon, members of the Commission. I'm Kristen Sullivan, Deputy Director of Community and Economic Development at Adams County. We do feel that counties should be included in this rule. Counties have been excluded, and we disagree with that exclusion. The issue of drilling in urban areas is also found in unincorporated areas of counties. As a point, we want to make clear the existing UMA facilities in Colorado, 9 of 14 are in unincorporated areas, and 3 of those are in Adams County. Adams County is a prime example of a county with urban issues, urban and rural edges, and large areas that are likely to never be annexed by cities. So the growth management areas would never apply to those areas because no city plans to annex them. We believe that all counties should be able to opt into the benefits of Recommendation 20, allowing for future land use planning in conjunction with the operator's business plan and drilling schedule. We think this is just good business. The communication would be beneficial to both the local government, long-range planning, as well as the industry during their preliminary site analysis. If the COGCC Commission is unwilling to include counties, we recommend some alternatives that might be good compromises. So those are found in our comments, but we'll go over them as well. One option would be including the U.S. Census metropolitan statistical areas that represents developed metro areas. That would include 22 counties to be eligible. Another option would be the MPO boundary metropolitan planning organization, like DRCOG, for example. That would allow the inclusion of 9 counties that surround the Denver metro area. Or the third alternative we've prepared is a definition of urban density that equals 300 people per square mile or more, as defined by the, for example, current 2010 census. That would currently allow for the inclusion of 7 counties. We think those recommendations might still uphold the spirit of the recommendation, which is to address areas where urban development's occurring, but not include all counties throughout the state. So that would preserve the intent of the task force recommendation while addressing some of those urban unincorporated neighborhoods. We think really that spirit of the recommendation is about looking at areas where urban growth is right up against oil and gas drilling, and that does not have to be in a municipality, as we find over and over again in Adams County. We want you to know that we believe county comprehensive plans have the same role and purpose as municipal comprehensive plans. And just if I could quote from a section of the recommendation, number 20, the rationale given was that local governments throughout the state have complicated and lengthy processes to develop comprehensive plans. The plan ultimately reflects the community's goals and aspirations in terms of land development and preservation. The plan guides public policy in terms of transportation, utilities, land use, open space, recreation, and housing. All of those things are true in Adams County as well. And as our commissioners mentioned during the public comment on the first day of rulemaking, we have 90,000 residents that live in unincorporated Adams County. They function in many ways just like any city. We're their only representative. The comprehensive plan is the only plan that they can look to for predictability about what's going to happen in their community. And we think it's very important that they have some of the benefits, and we really think that the industry could benefit too from knowing what the community's growth plans are for these areas. With that, I'd be happy to take questions.
Earlier today, we heard testimony from Adams County about relatively large areas, like butting up against the airport, that I thought were areas of planned growth. Did I misunderstand that?
I think that was Commerce City that spoke. Commerce City's in Adams County, and it's true. There are areas that are currently unincorporated surrounding Commerce City where there's planned growth of Commerce City. There's also very developed areas on the western side of Adams County, particularly at the Denver border and up to 168th. That's our northern boundary. That whole corridor along I-25 is a mixture of unincorporated lands and lands annexed into mostly Thornton and Westminster. In that area, there's pockets that will never be annexed because they're developed as residential and no city has any benefits to annexing those neighborhoods. And so we are their local government.
Commissioner Craig.
Okay, I'm trying to understand this. From a safety perspective, where is fire response coming from? I mean, I don't, who's providing fire response for these unincorporated areas? I mean, that would be the thing that I want to make sure is coordinated. And if you've got what sounds like these isolated groups, you know, how does that?
They're all covered by one fire district or another. There's local districts throughout the state that provide fire services that are not part of any city or county. Even in some cities in Adams County, for example, Thornton, fire services are provided by special district, not by the city. So in all of our unincorporated areas, there is a fire district.
Additional questions? Thank you very much.
Thank you for your time.
Just got one. So bottom line is you want counties to be able to opt into this.
That would be our first preference, although we've also suggested at least 3 alternatives where only some counties would be eligible and they would be primarily urban counties. And we think that might be a good compromise.
Okay.
Mm-hmm.
But essentially it'd be sort of the same outcome if we had an opt-in option It says, I want to be involved in this. If it was provided, then you could choose to do that. And since you represent 90,000 residents, and I think Jefferson County is some similar, although there's not a lot of oil and gas development.
I think opt-in for any county would probably be our best outcome.
Okay,
Thank you.
thank you very much. Commerce City, allied local governments. You guys are pretty lucky to have Mr. Zura at the head, at the steering wheel there. And the initial spokesperson is?
Kim Sanchez, Chief Planner at Boulder County. I'm sure it's of no surprise that I am here to testify to ask for your inclusion of counties into Recommendation 20. Recommendation 20 is one of the few entirely positive components of the proposed rules. It's a requirement that requires oil and gas operators to provide long-term drilling plans, but regrettably, counties are excluded from it. This is an exclusion that is most illogical to me. My question, I guess, is to you. Why wouldn't counties be included in this rule? There's no good reason not to include them. The spirit of Rule 20 is that the information is a planning tool to be used by local governments. Local government is traditionally conceived as a town, a city, and a county. To draw a distinction between a county and a city and town in this context is completely arbitrary. All local governments would benefit from understanding what the future of oil and gas development would look like in their jurisdictions. Counties, like municipalities, plan in a way to ensure that land is developed in a thoughtful and responsible way. Many counties have housing developments that are indistinguishable from dense urban development found in cities and towns. Arguably, counties will see even more oil and gas impact than cities and towns will see. If the goal of this rulemaking is to promote comprehensive planning to reduce conflict, it's unimaginable and decidedly poor policy to exclude counties. So more importantly, let's focus on how could this information actually be useful to us? What is the planning utility to counties? I'll give you 4 quick reasons. One is to allow us to plan for future activity. In planning, we look at things on set horizons. While to date, the heavy operations have occurred outside of Boulder County, for instance, similar pressures for the development of the resource are expected within our county lines. The information required in Recommendation 20 will allow us to understand realistic expectations for future oil and gas activity. Without this information, it's difficult to predict with any accuracy the number of wells our operators will want to drill in Boulder County and prepare for what to expect. Having this information would confirm the available capacity of our existing public facilities is not exceeded, and this is speaking namely to our county transportation facility. All of our roads are being used, whether the oil and gas facility is in our unincorporated lands or outside of them. It would allow for the orderly provision of public services, including, as Commissioner Craig alluded to, emergency response functions, such as those provided by our county sheriff, affected fire districts, and other first responders. Getting this information would allow counties to continue encouraging planned and orderly land use development. Second reason, to reduce incompatible land uses. We see this largely as an empowerment tool for both the county and operators and for our residents. More and more people are coming to the Front Range, and we need to plan for it in all aspects, including how to coexist where oil and gas development is anticipated. We see this information being important for our residents. In our office, for example, Boulder County Land Use Department, which is also typical of many local land use planning departments, we have planners on call who are available to field questions for any potential buyer of land in our jurisdiction. We want to be able to empower people with the information so that they can make their own decisions on what might occur around them, and give them this information up front when they first come to us to talk about obtaining permits. Someone moving into the area could make their decision based on knowledge, particularly because a mineral right isn't just one well anymore, but it's more of what we're talking about here today, a multi-well pad or a large facility. The third reason would be so we could evaluate cumulative impacts. We want to look at the impacts and evaluate the impacts that oil and gas development will have on the county incrementally and over the long term. Lastly, it's a resource issue. As a manager of a limited planning staff, who I've been largely absent for throughout these rulemaking hearings, administratively, this would help me evaluate if I have the adequate staff to respond to the number of applications we will receive based off the projections, and help me manage them accordingly. Most basically, this information is something that operators have. Why not be transparent and share it? Why not start the discussions early? During the outreach meeting, Director Lepore optimistically, and I've told him perhaps oversimplistically, suggested that I just pick up the phone and call operators and offer them a homebrewed beer if they want to come talk about their comprehensive drilling plans with me. If I really thought that would help, I would do it. But unfortunately, I don't think that we'd all be gathering in this room here today if that were the case. The whole reason we are here is for COGCC to play some sort of role as the middleman, unfortunately. But hey, there's a chance. And if any operator wants to get together to talk about their 5-year drilling plans over a drink, I am game. That said, I'd still like to see counties included in the actual rule. In all seriousness, the purpose of this recommendation and the rulemaking in general is to work on coordination between local governments and operators. Put politics, dynamics, and notions of whether you think a particular jurisdiction has the right to make the asks that they want, and think about whether this is good policy. You have the authority to do this. Please do what makes sense and allow for counties to benefit from this information.
Thank you. Any questions for Ms. Sanchez?
I wish we drilled in Boulder County.
5-year estimate, John.
That is not a problem. I'd be happy to provide that, especially for a beer. Question about, because we just talked previously about an opt-in process, would that as an option be satisfactory? Because then you would say that you would be able to obtain all you want. You could say, I want to participate in this process.
Sure.
Okay.
I really like that response.
We'll opt in.
Wow. Okay, any other questions? Okay.
Adam, excuse me. Adam Smith, I'm the Deputy County Attorney for La Plata County. La Plata County strongly supports the inclusion of counties within the definition of local jurisdiction under the proposed draft Rule 302C1. Because the vast majority of oil and gas development in Colorado occurs in the unincorporated areas of Colorado's counties, their omission from the definition of local jurisdiction is difficult to comprehend and justify. As an example, of the approximately 3,300 wells in La Plata County, only 10 wells occur within the incorporated areas. That equates to 0.3% of the wells. According to the La Plata County Regional Housing Alliance, over the next 20 years, La Plata County's population is projected to grow by 52%, which will require an additional 15,700 housing units. These forecasts are the mid-range projections, and thus the growth and housing demand could actually be higher. A significant amount of the growth and housing development will occur in unincorporated areas of La Plata County. As this population growth occurs, conflicts between new housing construction and the siting of oil and gas development is inevitable. If La Plata County was allowed to utilize the tools provided by Recommendation 20, that information would be invaluable to hopefully minimize the conflict between new residential development and oil and gas development through proper land use planning. The Commission should not deny all the counties in Colorado the long-term planning tools that will be provided by this rulemaking because one or maybe two jurisdictions do not want to use such tools. Those jurisdictions can simply opt out of the tools as set forth in the proposed draft Rule 302C3A. Thank you.
Thank you, Mr. Smith. Any questions?
So the opt-in would work for you too then?
I'm sure La Plata County would choose to opt in.
Growth projections are sort of scary to me. I have a dog in that fight.
I'm well aware, Chairman.
Erica Delaney Liu for the City and County of Broomfield. If I can, I would just like to ask all the commissioners to recall back to late in that first night of testimony in November. The City of Loveland, their attorney Tammy Yellico, and the City of Brighton's attorney Margaret Brubaker did come and also speak to this issue. They spoke a little out of turn because they couldn't be here for the continued hearings, but they spoke to the need for those communities to keep urban growth areas within this recommendation. And I believe Brighton spoke to municipal watershed and the importance they need to accommodate their growth area and their watershed. So I would just like to remind everyone of their testimony. That being said, the City and County of Broomfield wanted to appear today and speak to this. Rule 20, as Ms. Sanchez said, is very positive. It's very forward thinking. I personally read both of these recommendations together. I think the rationales of the two recommendations really fit together well. And what they are talking about is planning, trying to head off at the pass, so to speak, communities that are unhappy and really rallying against incoming oil and gas development. That being said, the proposed rule to implement recommendation 20 needs to require enough information from the operators to result in meaningful collaboration and planning. For them to just give us a map of the wells already existing within our community is inadequate. We can already pull that off your website, the Oil and Gas Conservation Commission website. For them to only give us a number of wells in the future, well, is that going to be one large-scale facility that they already have planned for 3 years from now? And they're just waiting until the 120 days or 90 days, whatever it is, before they start that notice process of recommendation 17? Or is that going to be 7 or 8 different sites throughout our community? If they already have this plan, what is the harm in talking about it, sharing it with us, and letting us start thinking about it, talking about it, and looking at alternatives if necessary in the long-range future? So at a minimum, for meaningful planning local governments, what we need the proposed location of expected future wells. Recommendation 17 spends a lot of time talking about having collaboration before the fixed site is finalized. Then why wouldn't recommendation 20 also want you to start communicating with the local government about proposed possible locations as far in advance as possible? We would need a description of the contemplated facility development. I say this because we need to have some sort of idea of the size and scope of that facility, but also that's useful for purposes of planning rights of way, ingress and egress points, all sorts of things that are part of a transportation comprehensive plan by a local government. We'd like to see existing surface use agreements that have been executed within the local planning area. The earlier this type of information is provided to local governments, the better the opportunity the parties will have to resolve conflicts between land use and oil and gas development. And that goes to the last point, which one of the commissioners already asked Director Lepore about. Planning is dynamic. It isn't static. The plan that a community might have for a particular parcel now could be different 7 years from now. It could be different 3 years from now. Sadly, it could be different in a year from now, depending on what the property owner and the prospective purchaser of that property owner have in place. Development is happening in Colorado everywhere. It's happening fast. The boundaries of communities are not even, well, the boundary of my community is static. It's set by constitutional amendment. But the boundary of other communities is dynamic. Cities are constantly annexing property. That changes both the unincorporated counties boundary and the city's boundary. Planning is dynamic, not static, and a one-time provision of this information grows less useful as time passes. Therefore, our recommended change to the rule includes at the end a provision that an operator shall provide updated information to the local government designee on an annual basis or as requested by the local government designee. We know that an oil and gas industry, when they make their 5-year plan, it's not going to be the same at the beginning of that 5 years as it is at the end of the 5 years. In most cases, their plan is going to change too. So the more frequently they communicate with us and collaborate with us, the better informed everyone will be, and the more meaning this recommendation regarding planning will be.
Do you wanted to see a copy of the surface use agreements that the company might have in your area?
So I know a lot of time has been spent, not today, discussing surface use agreements, and industry would like to see an exception for those. I don't know how they can justify needing an exception for something they're not willing to share to a local government who has yet to approve that location. So in the case where their plan is for a location that they already feel very justified that that location is the location where it has to be, why couldn't they share that surface use agreement? I mean, redacting out the price or financial information that they didn't want to share. With regard to the location, I don't understand why that's not something they can't share.
Commissioner Craig?
What you're asking for, and I want to go on record as saying, because I started off my career at one point in a budgeting process, and I worked for, a few years ago within a budgeting process, and then in senior management, I was always concerned about it. I can totally tell you that 5 years, no. We're talking about an 18-month period where what you start off with 18 months is not going to be the same in the budget at the end of that 18 months. Within an oil and gas company, even before these prices started to do this roller coaster, the change of a corporation's plans were extremely dynamic. You are requesting for a certainty that I have never seen in almost 40 years in this business. 5 years, please. 3 years, please. 18 months, I don't even buy that. It just, and then when you start throwing in all this with price, you're asking for a certainty of the industry that I have never seen exist.
Well, and I guess to your point, I think that's important why there has to be language about it being updated. Certainly the nature of the recommendation now is that it is estimated, it's projected. Nothing is finalized at this point, but I think the 5 years really stems from the difference between perhaps industry is, you're saying 18 months is a decent gauge for industry. A comprehensive plan can be in place 10 years out. That's not to say that it can't change. It certainly can change, but recommendation 20 and talking about local government comprehensive planning, that's a much longer term plan than say the 18 months would be. So I don't know if the task force or the staff came up with 5 years trying to divide the difference between those two and bring them close together. But the more information we can get, and the earlier, the more meaningful we can use it in our long-range planning.
I understand what you're asking, but until the actual funds are set aside in a budget for full-scale development, you are dealing with a huge amount of uncertainty. We used to refer to the 1 + 11, the 2 + 10, we may get to the 4 + 8, and each and every time the program of wells was changing. I'm just saying that this is more dynamic than you think until the corporation votes on the AFE and says, we're going to go ahead and do this development. That future stuff, 5 years in advance, I can guarantee you there is not the remotest chance that it's going to look like what it was at the beginning. I mean, you're asking for certainty that does not exist, and you just need to know that.
Commissioner Benton, I bet.
We've come to the point, it's a difficult thing to say, but I have to disagree. So, notionally, I think what's being asked is a best estimate. We all have to do 5-year plans, and tying it, we can't book a reserve as proven undeveloped unless we have funds in the 5-year plan to go drill it.
Agreed, on the 5-year budget.
And
I
it does
agree.
say that in there. I think it's best estimate, and we're allowed to change that at any time. I think where I tend to agree with you is if the local governments tend to take that as a given that this is what we're going to do, then there will be an issue. Because Commissioner Craig is exactly right, is that we talk about it, there's a 40% probability that you will execute in the first year of your budget everything you planned at year 1. When you start in January, you get to the end of the year, it's a good year when you do 60% of what you plan to do, because if things change along the way, be it price, approved permits, find something different, you want to accelerate something, you want to cut back somewhere else. So I think the concern that I have is that this is going to be taken as a given. It says, okay, you said you're going to go do this, and then we've come under fire because we didn't go do it because of something changed. So, so that's a comment. The question I would have is that, to some extent, what I haven't heard out of this is that we have to sit down and say, well, here's everything that we're going to do. There's nothing in here that tells me, it says, well, now the county or the local government is going to tell me, well, here's what our development plans have. Here's where we tend to, here's where we're going to put in the next housing development. Here's where the next schools are going to go. So we're sort of left, oh, here, we feed you everything and you tell us nothing. That doesn't help us very much either.
I have a response to that. Our comprehensive plans are public documents. So certainly, local governments are not trying to, nor are they permitted to hide the ball with what their future development, what areas are slated for what. Those are public records. And I actually think, looking back to this, if this is to start the conversation earlier, I think industry, in response to this, the communities that opt into this, they're going to be met with people who want to speak with them, who want to talk with them about, in most communities, about where plan together that path. And then to your first point, there is language in the draft rule that says specifically estimates provided by the operator may be subject to change at any time at the operator's sole discretion. So that language is already in there. We certainly understand that these are only estimates. You would not be bound by them. And conversely, providing this information to us does not preempt or cut out the local process later for individual plans and operations.
I think I'd be a lot more comfortable if it said will be subject to change, not maybe. I think we'd probably do. And a lot of what we put out, particularly if you're a public company, we also put out public documents about what our budgets are and our plans are, because I think especially you look at some of the larger operators, they put out information, Noble and Anadarko both, about what they plan to do over a 5-year period of time out here in Greater Wattenberg. And of course, that's greatly changed. So I think that there's, again, it's a two-way street, is that if we're going to share something, the expectation would be to come back and say, well, we know this is a public document, but let us share with you what our plans are and what we're headed and what we're planning on doing.
Are there questions?
Yes.
Commissioner Allward.
Thank you, Mr. Chair. Thank you all for coming before us right now. And I got a sense now of something that everybody who's been before us agrees upon. And that is that everybody who's come before us wants certainty and flexibility. But where they want that certainty and flexibility differs. And that's, not getting into quasi deliberations. That's what we're going to have to wrestle with next year. So, I'd like to see that some of that, while you're thinking about your closing statements and what that's going to be, that you include how you see us wrestling with that certainty and flexibility. I think, we're constantly being told by industry, we're given 5-year projections of what's going to happen, and that's based on conditions that could be reasonably anticipated or with business as usual, whatever. And we all know that those are fiction. I mean, my grandmother knew my 5-year plans were fiction. So, but it made her happy that I had one. And I think everyone would, and I would hope that if you had a relationship that an operator is giving you a 5-year plan, that you would, as you're working through your process, that you could come and ask that operator and say, we're going to be developing this area now. Where do things work out in your plans now? Are you still going forward with this proposed development? And that would be a two-way street. I mean, I would assume that that's something local governments can do. I don't know if it's true.
If that's a question.
It's free time for you to.
I would agree that that's something that local governments do. And I think, speaking only for Broomfield here, I think that that's a process that we're going to engage in more after this rulemaking, probably trying to do more outreach to industry directly. But as Commissioner Craig said, the rulemaking is not for the best operators who are already exceeding industry standards. The rulemaking is for the operators who maybe don't want to come to the table, who maybe won't respond to my calls, and who won't go out to beers with Kim Sanchez. The rulemaking is for that baseline. And I know that you have a lot of probably high-end industry operators here that don't want to have rules. But the most simple analogy that I can think of is, I'm sure no one in this room would ever exceed a posted speed limit, but there are people out there who might. And are we going to all vote to not have speed limits because none of us would do it? I mean, it's not, that's the most basic analogy that I can come up with, and it really arises from something Commissioner Craig said. The rule is to bring up the bottom, and you all are charged with drafting it in a way that it doesn't demean or reduce the innovation that the operators on the top are showing. So thank you for your time.
If I could respond to your question as well, I do think that it's a two-way street. I do think that this would be a first step for a local government to also reevaluate our own land use code. For instance, in Boulder County, we have a number of uses that are by right in the agricultural zoning district, which is primarily where the Wattenberg is. Maybe we could reevaluate whether all of those uses are actually compatible with oil and gas development that we are expected to see in certain areas.
Commissioner Craig?
And this may be directed more towards the gentleman to my left. Are there IGAs between counties, towns, and cities?
Yeah.
Okay.
Fort Levin's got an IGA with Will County right now. So when somebody brings forward a project, part of the requirement that we require at the city and the county is that they give notification to the mineral owners of that property. So when they come in and they want to develop it or put a big building on it or whatever, they've got to let somebody know, and that brings in the operators to the table to say, we've got the lease, let's work on this.
Okay. Thank you all very much. Colleagues, you need a break, or shall we proceed with industries? You mean you want a 5-minute break, just a leg stretch? That's 5-minute break. Okay. Okay, Mr. Nesland, Ms. Jost.
Thank you. Well, with respect to recommendation number 20, industry has 5 most in support, straightforward points regarding this recommendation. I'm not going to read to you what's up on the screen as slide number 81, but it's very clear that the recommendation was intended to apply to municipalities only. Our position, industry's position since day one, has been to stay within the 4 corners of the recommendation. Based on this recommendation, we would make one requested change to the definition of local jurisdiction that is contained within the staff's proposed recommendation. And all that is to include the term combined before the term city and county. While we believe that it is clear by virtue of the definition that city and county are one and the same, just for purposes of clarity, we would like to add the term combined. That was the first point. The second point is the industry supports the staff's exclusion of counties. The exclusion of counties, or the inclusion of counties, would increase the burden of operators significantly because of much greater size of counties. This was considered during the task force and was ultimately rejected, and that the counties can actually pick up the phone, as Ms. Sanchez called or said, and call the municipalities with respect to that and receiving that information. The third point in support is that we do support the applicability of the rule to both private and public companies for informational purposes. The fourth point in support is to support the inclusion of the term drilling and spacing orders and striking the final piece of the proposed rule regarding the locations on the current drilling plan that are not pending, I would say permitted or pending with the state at this point in time. The last point that I would like to make before I turn it over to Mr. Nesland is that the industry does not support expanding the rule to the jurisdictional growth management area. This term is undefined and does not provide the requested clarity. And if a municipality does extend its boundaries, then that municipality can request updated information from that operator pursuant to the terms of the proposed rule at this point in time. With that, I'll turn it over to Mr. Nesland.
Okay. Commissioners, I'm going to add just a couple of points to what Ms. Jost has said. First, it makes sense to limit this provision to municipalities because land development and land use changes typically occur more rapidly and are more prevalent at the municipal level. So that is the appropriate focus for this sharing of information. Municipalities are also much more compact. Expanding this rule to counties would increase the area covered by many, many orders of magnitude, and it would accordingly make this obligation many, many times more expansive and onerous. Counties also can request information from operators, and many do so already. For example, counties in the DJ Basin, on the West Slope, down in the Four Corners area meet periodically with operators for this very purpose. So, as Ms. Jost noted, this rule is not the only recourse that a county has. There's also the telephone. Last, if this rule proves to be useful, its scope can always be expanded later. This rulemaking is not your last regulatory rodeo. This commission is the Professional Rodeo Cowboy Association of rulemakings. There will be additional opportunities to adjust this down the road. Let me stop there. We'd be happy to answer any questions.
Any questions? I have to congratulate you both. That was very nicely done.
So, and being, I think, may I?
Yes, sir, please.
Mindful of what Commissioner Craig said earlier about sort of, we're not concerned about so much about the operators that are willing to share when the counties pick up the phone, more so those who are not. And in what case, how do you address that? And I'm mindful of Adams County, which said there's 90,000 residents in unincorporated Adams County. I would wager there's a significant number of people that live in unincorporated Jefferson County that also live within essentially a municipal area. So how do you propose to address some of those issues if we don't provide a chance for the counties to opt in if they want to?
So I think there are many responses to that. First, it goes without saying, there are people who live in unincorporated areas of the state. I don't think anybody disputes that. So
we're talking about where it's fairly high density population, not out where jackrabbits carry sack lunches.
And there are a wide variety of housing situations in different areas. Again, local governments can ask to talk to operators in those areas. Many do so already. Local governments can convene regular meetings with operators like the West Slope local governments do, I think a quarterly or biannual basis. Weld County does down in the Four Corners. The commission and local governments meet with operators. Larger operators present information in public information through their public securities reporting. And again, this is a new approach in terms of sharing information. We can add to this approach down the road if it makes sense, if it in fact is helpful. I think there's going to be some real questions about how this works. And one of you raised the issue in a question to the preceding panel about what will be the role of local governments in terms of sharing information with operators. Where is residential development anticipated? Where are plat or PUD applications, where do those cover? What kinds of development plans does the local government see over the next 18 months or 3 or 5 years? So I think it's going to take a little while to work through some of these issues in practice. And again, if this works, if it's helpful, this can be expanded to the county level. That's a big expansion. And I would wait and see how this works as kind of a test at the municipal level first.
Other questions? Okay, Ms. Murphy, are we at a, what's that big word for asking questions?
Are you thinking of rebuttal?
That's it. Are we at rebuttal stage?
Thank you.
Any rebuttal?
Yep.
Oh, my goodness. Is it Adams County?
Good afternoon, Kristen Sullivan, Adams County. I just have a very brief point I wanted to clarify. I think we heard 2 times about what information would the counties and cities share back in this exchange of information. I think that's exactly the purpose of it, is that mutual exchange of information. Our comprehensive plans are a guide for the next 20 years or so, and so they are very dynamic and very fluid. And there's a strong possibility that if there's a location that has not yet been developed that is very important to an operator, we could plan around it if we were to be able to share that information with them, and then we could find a way to direct development to go in other areas and kind of keep that undeveloped and prevent the encroachment of the urban development. And so I think from our perspective, there's a real genuine intent of wanting to share our development information, and not only just share it, but craft our development plans in a way that's compatible. And so I think, I just wanted to make that point, that I think we're coming from this in terms of very much a mutual exchange, and also knowing that our plans can also be molded in a way that results in compatible development.
You probably have heard some concern, I think, expressed that you're going to get information from a oil and gas company about their tentative proposed 5-year plan, and then you're going to decide to build a really nice new county road out where that oil and gas development's going to be, and it never goes there. You understand that concern? Does that give you false information that you're going to plan on?
No, I think that it would be helpful to have the best available information at a given point in time, and then to continue to develop those relationships with the operator so that we can update that as soon as possible when plans change. Just like the comprehensive plans are certainly no predictions of what will happen. They're a guide, a vision, but we can't anticipate, how the market for development will change. And so a lot of times the timing's not right in our plans, but eventually those plans will come to fruition, but they could be 20 years off in time, for example.
Question, Dr. Allward.
Thank you, Mr. Chair. So when you're putting together this comprehensive plan, this development plan, do you provide public notice that you're going to be working on this?
Yes.
Can anybody come and participate, add their input and watch what happens?
Yes.
And then when you come up with an end product, it's publicly available?
It is publicly available.
Okay. Thank you.
Other questions? I'll go ahead. You may go. Okay. Effective date and conforming changes and
that's the last topic today.
Okay, unless there are remaining issues.
I believe we are going to loop the remaining issues and closing statements and hold those for January is what we talked about earlier.
Thank you. Okay, effective date and conforming changes. Let's grant the staff just a little bit of time to address that. That'd be okay?
At your discretion.
Right now. I want to ask council a question. What does loquacious mean?
What is the opposite of loquacious? I will.
This side of the table.
Thank you again, Mr. Chairman. I think I'll dispense with the slides. Are those my slides? No, I'll dispense with the slides. I have 3 points to make here. Staff proposed that the best management practices part of these proposed rules should apply to applications that are pending at the time you all approve whatever you approve. So I guess as of January 25th, if there were an application pending that met the definition of large facility in an urban mitigation area, we would apply these best management practices to that location. We think the reasoning for that is operators are pretty much on notice at this point about what those look like. I could make the argument that we think we probably could apply most of those anyway under 305E. It just seems to make sense, again, for these large facilities in the urban mitigation area. We wouldn't, of course, make them go back and do any of the notification and consultation that the rule contemplates, but hard for us to understand why a prudent operator wouldn't want to use these sort of best management practices in any event. We have asked to change the timing right now for a Form 2A. If staff has not approved that within 75 days, the operator can ask to have a hearing in front of the commission. We know that it takes us a little bit more time to evaluate these complicated sites that are in the heart of urban mitigation areas or the heart of densely populated areas now. So we've asked for an extension of that to 150 days before they could come and seek a commission hearing. There are some off-ramps for that if they have an agreement with the operator or with the local government and so forth. that might be an area where we have a little room to move if there was a little room for movement on the other side. But that's what we've asked for. All of my other remarks relate to consultation. We'd like 40 days for public comment for Form 2As in large urban mitigation areas. We'd like to have into these rules explicitly the right of the director to extend or reopen any comment period for up to 20 days. One of the more consistent themes we hear from the public right now is that an application comes in, as soon as it's deemed complete, that's the comment period starts, it's 20 days long. A lot of changes happen to those Form 2As, especially again in these more complicated situations. And the public asks us, well, why do we have to comment before we really know what we're commenting on? So that's the reasoning there. And last but not least, we think it's appropriate that we consult, that COGCC consults with CDPHE on all Form 2As that meet the large urban mitigation area facility definition. So those are really the only comments I have on effective date and conforming changes.
You assume there are no wildlife issues in these urban mitigation areas?
Mr. Chairman, you kind of stumped me. That's not necessarily my assumption, but I think my assumption is that if we were in a sensitive wildlife habitat area, we'd have to consult with the Department of Parks and Wildlife anyway.
Okay.
So I think the size and proximity to homes is not relevant in that context.
Any questions for the director? Thank you very much, sir.
Thank you, sir.
Nicely done.
Not loquacious.
Citizens group.
I may need to get Mr. Soro's help up here.
Matt, I think he's serious.
There we go. I am Dan Johnston with Windsor Neighbors. I would like to address one of the topics that the director mentioned, and that's Rule 305D on the comment period. That's the rule as somewhere it's currently in the rules. The staff has made some changes to it. They've redesigned, reformatted it a little bit, added 3 areas of text. The first 2 are actually only to recognize the proposed definition of a large UMA facility. But it's the third one that Mr. Lepore addressed that I would like to comment on. They have added the language that at the director's sole discretion, any comment period identified above may be extended or reopened for a period not to exceed 20 days. And we appreciate the staff's recognition that something additional needed to be done other than what's currently in the rule. But in the honored tradition of that old necessary and sufficient paradigm that we learned back in math years ago, we believe while that's necessary, it's not sufficient. It's not sufficient for this reason. As Director Lepore alluded to, there are applications that are complex and not complete or correct by the time the comment period ends. And we trust that it's the intent of this commission and the staff that the comments from the public be meaningful. And we suggest to you that they cannot be fully meaningful if they are commenting on applications that are not complete and correct. So we would ask the commission to add the following language. In no event shall any comment period terminate before 10 days following the director's certification posted on the COGCC website that all forms identified above are correct and complete. That would give the public 10 days to comment on applications that the director has certified are complete and correct, and we believe that would open it up to more meaningful participation by the public. One other thing we did was we also added the word further in our recommendation just for clarification in the director's addition to the language.
Okay, any questions for Mr. Johnston? Thank you very much, sir.
Thank you.
If we're keeping up with tradition, Catherine?
Yes, sir. No comment.
West Slope?
Thank you.
Adams County? Commerce City? Dare I say allied local government? We have, I think we know Wales' opinion, industry.
Thank you. We just have very brief comments. First, with respect to the effective date, industry does not believe there's a need to have retroactive language to the pending applications. The state has already confirmed that potential COAs, BMPs, and mitigation measures can be placed on pending permits. The rule does not need to expressly state this. This would be the first time there would be retroactive applications stated such in the rule, and therefore we just do not believe it is needed at this point in time.
I'm sorry, Ms. Joseph. Just, do you mind doing that one more time?
Absolutely. So with respect to the effective date, there's language in there that states that if you have a pending application that would basically be considered a large EMA facility, you would not need to go through the notice and consultation procedure, but you would need to go through basically the review of best management practices, mitigation measures, or certain conditions of approval. The effect of that with respect to the being placed in the effective date provision of the rules applies the rule retroactively. The commission already has the authority, if you have a pending permit, to put BMPs and mitigation measures on those permits. Industry does not believe there needs to be basically retroactive language in the rule. Nowhere else in your rules is there a retroactive application of a new rule at this point in time. So we believe it's unnecessary, and it actually tracks very similarly to the reason that duration was removed from the rule. With respect to Rule 303C2, we do not believe that there is a need to change the timing to 150 days from 75 days for approval of the Form 2A permits, 2 or 2A permits, basically for a large EMA facility. If the COGCC LGD would participate from the date of receipt of notice, then they will be involved during the evaluation process of that large EMA facility and will have the ability to either know or potentially provide comment for the potential BMPs and mitigation measures that may relate to that facility. The early involvement of the COGCC could help on the back end of the Form 2A review, and the COGCC staff would not need an additional 75 days. The UMA process as proposed is already long enough, and when there's an additional 75 days added to the review and potential approval or denial of that pending permit, that is just an additional 75 days that an operator has to deal with in an already long process. With respect to Rule 305D, and this is relating to the comment periods, industry believes that the comment period should be no more than 40 days and should track the current notice period for an urban mitigation area, Form 2A, and the language of that would be found in your current rule, 305D1B, where it states that, sorry, my eyes are bad, the director shall extend the comment period to not more than 40 days upon written request for a local government designee received within the original 20-day period. And that is for Form 2As filed in a local or an urban mitigation area. Again, we believe that in potentially additional 20 days, which is set forth in the state's rule of 305D3, should be deleted. There's new language added in 305D3 from the state's rule that says that the director may allow an additional 20 days as a whole to the comment periods. This is not just large UMA facilities, but this is to the 20-day comment period and the current 40-day comment period. Again, with respect to the involvement of, upfront involvement of local jurisdictions, an additional 20 days on a comment period does not support the statute that provides for timely permitting turnaround time. And at this point, we just believe it would be unnecessary. With that, that would wrap up our testimony on effective date and conforming changes. And I would just direct you to the COGCC draft rule that's in your packets, as we do have cleanup language on that proposed. Thank you.
Thank you. Question? Commissioner Benton.
And I'm sorry, I was trying to write, and it's hard at this point. It's hard to chew gum and walk at the same time. Could you go back through just that last piece about the comment period again, so I'm sure I understand your position?
Absolutely. If you look at, and I don't know if you have it in front of you, but the state's draft rule under Rule 305D for comment period, it would be under Section 3. It states, at the director's sole discretion, the comment periods identified above may be extended or reopened for a period not to exceed 20 days. What that does is basically that extends all of the comment periods. You have a 20-day comment period if you're not within an urban mitigation area. You have a 40-day comment period in an urban mitigation area. And then you have a 20-day comment period if you have a large UMA in a local government area that has reached an agreement with an operator. And then you have a 40-day comment period in a large UMA facility with a local government and where the operator has not reached an agreement. Effectively, what the language of extending, allowing the director's sole discretion to extend another 20 days, you could result in a 60-day comment period. I don't believe that was intended to occur in these rules. A 60-day comment period, again, could just be detrimental for not only potentially an operator's plans. We want to make sure there is open communication with that, but there is also the ability to have the commission issue an approval or denial on a permit within an efficient amount of time.
So essentially, it's a 40-day cap regardless of what it says.
That's what we would request.
Okay.
Yes. Thank you. And Commissioner Benton, really what that does, if you look at 305D1B, we would request that the language track the current language for oil and gas locations within an urban mitigation area that says the comment period shall be no more than 40 days.
Okay. I wrote that down, but so.
Okay. Thank you. There's a lot of numbers in there.
Other questions? Thank you very much. Rebuttal on this issue. Hearing none. Then we are like really close to the end of today's session. Commissioner Hallward.
Just before we run away, I just wanted to ask staff, and in particular the director, to make sure over this next month or whatever it is that you're, as you're working on the reconciliatory language, that you're reaching out to all the groups and kind of keeping them in aware of what changes might be coming, so that then they can be directing their arguments also, so that what we get for January are very concise arguments, well thought out of where they differ from the staff's proposal. So I think that would really help us come up with a good reconciliation in January.
I hope the director understood what you said, because I didn't.
I'm not sure I can repeat it, but well, I'm asking the director
we're shooting for him to, his staff to have something out 10 days before, by January 15th.
But I think that since in some cases that he'll probably want to run an idea out or let other parties know what he's thinking, that he does that so that those parties then come back with good information for us that in their closing statements that will facilitate a good decision on our part.
I would assume he has, what's that word, flexibility to do that.
I want certainty.
And flexibility.
Which reminds me, somewhere I kind of recall, these folks are going to give us a 5-pager. What kind of time constraint do we have on that? Or do we?
Currently, there isn't one. Oops. And in part, it will probably depend on when staff's draft comes out.
Okay.
And
The point, the point is well made and heard. We won't languish. We will be in constant discussions, I guarantee you, between now and the next hearing. So I think we can expect staff within prior to the holidays, the new year, at the absolute latest, get a new draft out, and then set a time frame for a week or two to get briefing in. So we have a week or two to read them, and I think that's a rough parameter of what we're going to be looking at over the next month and a half.
Okay. Colleagues, Commissioner Craig had to step out for a conference call. No, just so you know that. Okay, then we'll conclude today's hearing with the idea of reconvening on Monday, January 25. Is that correct?
reconvening this hearing on Monday, January 25 at 9 a.m. You will be reconvening tomorrow morning at 9 a.m. at COGCC's offices, though.
Oh, by the way, just in case you're up for it and are interested, we'll have a regular commission hearing tomorrow, beginning at 9 o'clock up at COGCC offices. So thank you all very much. See you later.
Staff would not need an additional 75 days. The UMA process as proposed is already long enough. And when there's an additional 75 days added to the review and potential approval or denial of that pending permit, that is just an additional 75 days that an operator has to deal with in an already long process. With respect to Rule 305D, and this is relating to the comment periods, industry believes that the comment period should be no more than 40 days and should track the current notice period for an urban mitigation area, Form 2A, and the language of that would be found in your current rule, 305D1B, where it states that, sorry, my eyes are bad, the director shall extend the comment period to not more than 40 days upon written requests for a local government designee received within the original 20-day period. And that is for Form 2As filed in a local or an urban mitigation area. Again, we believe that in potentially additional 20 days, which is set forth in the state's rule of 305D3, should be deleted. There's new language added in 305D3 from the state's rule that says that the director may allow an additional 20 days as a whole to the comment periods. This is not just large UMA facilities, but this is to the 20-day comment period and the current 40-day comment period. Again, with respect to the involvement of, upfront involvement of local jurisdictions, an additional 20 days on a comment period does not support the statute that provides for timely permitting turnaround time. And at this point, we just believe it would be unnecessary. With that, that would wrap up our testimony on effective date and conforming changes. And I would just direct you to the COGCC CPA draft rule that's in your packets, as we do have cleanup language on that proposed. Thank you.
Thank you. Question? Commissioner Benton?
And I'm sorry, I was trying to write, and it's hard at this point. It's hard to chew gum and walk at the same time. Could you go back through just that last piece about the comment period again, so I'm sure I understand your position?
Absolutely. If you look at, and I don't know if you have it in front of you, but the state's draft rule under Rule 305D for comment period, it would be under Section 3. It states, at the director's sole discretion, the comment periods identified above may be extended or reopened for a period not to exceed 20 days. What that does is basically that extends all of the comment periods. You have a 20-day comment period if you're not within an urban mitigation area. You have a 40-day comment period in an urban mitigation area. And then you have a 20-day comment period if you have a large UMA in a local government area that has reached an agreement with an operator. And then you have a 40-day comment period in a large UMA facility with a local government and where the operator has not reached an agreement. Effectively, what the language of extending, allowing the director's sole discretion to extend another 20 days, you could result in a 60-day comment period. I don't believe that was intended to occur in these rules. A 60-day comment period, again, could just be detrimental for not only potentially an operator's plans. We want to make sure there is open communication with that, but there is also the ability to have the commission issue an approval or denial on a permit within an efficient amount of time.
So essentially, it's a 40-day cap regardless of what it says.
That's what we would request.
Okay.
Yes. Thank you. And Commissioner Benton, really what that does, if you look at 305D1B, we would request that the language track the current language for oil and gas locations within an urban mitigation area. This says the comment period shall be no more than 40 days.
Okay. I wrote that down. But so
okay. Thank you. There's a lot of numbers in there.
Other questions? Thank you very much. Rebuttal on this issue. Hearing none. Then we are like really close to the end of today's session. Commissioner Hallward.
Just before we run away, I just wanted to ask staff, and in particular the director, to make sure over this next month or whatever it is that you're, as you're working on the reconciliatory language, that you're reaching out to all the groups and kind of keeping them in aware of what changes might be coming, so that then they can be directing their arguments also, so that what we get for January are very concise arguments, well thought out of where they differ from the staff's proposal. So I think that would really help us come up with a good reconciliation in January.
I hope the director understood what you said, because I didn't.
I'm not sure I can repeat it, but well, I'm asking the director to.
We're shooting for him to, his staff to have something out 10 days before, by January 15th.
But I think that since in some cases that he'll probably want to run an idea out or let other parties know what he's thinking, that he does that so that those parties then come back with good information for us that in their closing statements that will facilitate a good decision on our part.
I would assume he has, what's that word, flexibility to do that.
I want certainty.
And flexibility.
Which reminds me, somewhere I kind of recall these folks are going to give us a 5-pager. What kind of time constraint do we have on that? Or do we?
currently there isn't one. Whoops. And in part, it will probably depend on when staff's draft comes out.
Okay.
And
The point. The point is well made and heard. We won't languish. We will be in constant discussions, I guarantee you, between now and the next hearing. So I think we can expect staff within, prior to the holidays, the new year, at the absolute latest, get a new draft out, and then set a time frame for a week or two to get briefing in. So we have a week or two to read them. And I think that's a rough parameter of what we're going to be looking at over the next month and a half.
Okay. Colleagues? Commissioner Craig had to step out for a conference call. No, just so you know that. Okay, then we'll conclude today's hearing with the idea of reconvening on Monday, January 25. Is that correct?
reconvening this hearing on Monday, January 25 at 9 a.m. You will be reconvening tomorrow morning at 9 a.m. at COGCC's offices. So.
By the way, just in case you're up for it and are interested, we'll have a regular commission hearing tomorrow, beginning at 9 o'clock up at COGCC offices. So thank you all very much. See you later.
Birthday slash